Judge, did you get the email?
Yes, thank you.
You're welcome.
Good morning, courtroom 2. And 4 North, good morning.
Good morning, sir.
How you doing?
Good morning. Who do we have at 4 North this morning?
Yeah, number 15, Mr. Jeffries.
That's your client, Mr. Ford?
Yes, it is, Your Honor. And hold on, I think the jail is called. I have one client that needs to be, was supposed to have been released, but he's not released. So just give me a minute.
Good morning, Ms. King. How are you today?
Good morning, Your Honor. It's good to see you.
You also.
All right, I'm all set, Your Honor.
Okay, very good. Good morning, Mr. Jeffries. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you. And if I understand it, Mr. Ford, this is going to be a non-negotiated plea?
Yes, it is, Your Honor.
Okay. Ms. King?
Yes, Your Honor. The state is, the offer that the state presented was for count 1, 12 months to serve, 32 days, credit for time served, 16 days with the balance probated, 60 hours of community service, restitution in an amount of $400, and no violent contact with the victim. For position 3, it is 12 months to serve, 40 days, credit for time served, 16 days with the balance probated, a stay away from the incident location, and is to be served concurrently with position 1. And for count 2, that's time served, 16 days. On August 21st of this year, Sergeant McNamara of Roswell Police Department advised over the radio that There was a stolen bike from the Exxon gas station located at 1105 Unit A in Holcomb Bridge Road, which is in Roswell, Georgia, which is in Fulton County. The victim in this case, Dionico Ortiz, Tiz, stated that his bike had been stolen from this incident location, and the officers began patrolling the area for this bike, and they were able to see the defendant, who was identified by his clothing, take the bike, and the victim was able to provide documentation that this bike was worth $400. Ultimately, the defendant was apprehended with the bike, and there was a glass pipe on his person with residue inside of it. And at that point, he was detained. We're not offering jail time in this instance, but the victim is adamant that he needs the restitution for his bike. This is how he gets around. This is how he gets to work. So we feel that is more than reasonable under the circumstances.
Did he have a prior theft by taking? Ms. Garrison, good morning. How are you? I'm sorry, Ms. Garrison.
Oh, I'm sorry.
Ms. Harrison, how are you this morning?
Good morning, Judge.
Does Mr. Jeffries have a history?
15 cycles, last arrest July of this year, probation violation. Underlying charge is not indicated. Record does indicate an open probation in DeKalb for possession of cocaine, possession of methamphetamine, criminal trespass, case number 21 CR 1704. Sentenced July of this year, 5 years probation. Additional open probation in Fulton County. Possession of tools for the commission of a crime in entering auto with intent to commit a theft or felony. 21 SC 178055. Sentenced September of 2021. 30 months probation.
So no theft charge, no prior theft charges?
I'm checking now, Judge. One moment.
Good morning, Your Honor. Respectfully, the state will consider an entering auto a theft charge.
Good morning, Mr. Walker. Thank you.
No prior theft, Judge.
Okay, all right. So, Mr. Ford, I see that the issues are the no-low. I'm going to allow him to use the no-low. Restitution, he's going to have to pay $400 in restitution. I don't see the jail times at issue, and I don't see that 60 hours of community service is egregious in this case. So, with that said, you can go ahead with your argument.
Thank you, Your Honor. Your Honor, there is a jail time issue. If you would note on count 3, it says 40 days credit for 16, which would get my client would have to do 4 more days in jail. So that's why we're contesting the jail time. If the state is willing to align that with the 32 that's in count 1, I think we would definitely be agreeable to that.
Yes, the state is agreeable to that.
All right.
Okay, so it's it'll be a time served plea.
Yeah.
Correct,
Thank you, Your Honor. And also, Your Honor, I think it was even stated by the ASG that the bike was recovered. So I don't know why there's a $400 restitution when the bike has been recovered. They saw my client with the bike, and the bike was covered by the police, Your Honor. And so at this point,
Your Honor, if I may, let's bring back the way you stated to you. Your Honor, it does not state, my apologies if I misspoke. It does not state that the bike was recovered, which is why the victim likely was requesting the restitution in this case. My apologies to the court and PD Ford if I misspoke.
well,
So it's either going to be return the bike or pay $400.
Correct.
all right, we're agreeable to that, Your Honor. And
Okay.
also, my client does not have sufficient means, Your Honor. He has no transportation. His job that he has, if he still has it, does not pay enough for him to do the 60 hours of community service. I know that community service is just my client attending, but there's hours in preparation of going, coming, and he does not have transportation. Your Honor, he felt that it could be reduced to 20 and he could probably find a place that he could walk to. So we're asking that the 60 hours of community service, due to his limited means, because I think we're setting him up to possibly fail if he goes try to do 60 hours, because he's definitely trying to keep his job and he has no transportation, Your Honor. So now that jail time has been aligned, I think we're okay with the restitution. If the bike is recovered, my client will not have to pay $400. Yes, we are asking for a NOLO. Thank you, Your Honor, for agreeing to that. But we're asking for 20 hours of community service, Your Honor.
I don't think the 60 hours is egregious in this case, especially since I'm allowing him to use his NOLO. He can do 5 hours every weekend. He'll be on probation for 12 months. He can get 60 hours of community service done.
All right, Your Honor, once he completes the community service, can we have?
I have no idea. This is really
Mr. Walker.
Mr. Walker, mute. Ian, mute.
But after we finish this, if you want to ask
Someone,
Ian, mute yourself.
Walker, please. Thank you. I'm sorry, Mr. Ford, go ahead.
Thank you, Your Honor. We're asking that his probation fees be waived, and also once he completes the community service, that his probation be terminated.
Any objection to termination?
Not at this time, Your Honor.
All right. Anything further before we take the plea?
Nothing further, Your Honor.
Nothing from the state.
All right. And I just want to make sure that I did swear Mr. Jeffries in. Mr. Jeffries, it's my understanding that in case 22 CR 005600B, you wish to plead NOLO to theft by taking, possession and use of drug-related objects, and criminal trespass. Is that correct?
Yes, sir. Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading NOLO to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead NOLO?
No, Your Honor.
I will accept the NOLO pleas. The sentence will be for the theft by taking 12 months to serve 32 days, credit for time served 16 days, balance probated, 60 hours of community service, restitution in the amount of $400, or return the bike, and no further contact with the victim in the case. For the other 2 charges, it'll be 12 months to serve 32 days, credit for time served, 32 credit for time served 16 days, and these are to run concurrent with position with the theft by taking. All right, anything further on Mr. Jeffries?
No, Your Honor.
All right, who do we have next?
Your Honor, can we go to all of Mr. McLean's cases? Mr. Ford has several clients that need to talk to him, so I have them lined up to talk to him on the phone, if possible.
Okay, that's fine. And I see also Mr. Schwartz on the line. If we can take his client.
His client hasn't been brought over from
Cobb County.
from the jail.
Is he gonna? Are you all expecting him today?
Yeah, they just didn't bring him over yet, Your Honor.
Okay, all right. So I tried, Mr. Schwartz. Sorry about that.
Your Honor, could I ask that the jail? I want to talk to Mr. McDuffie, because he was told him he was supposed to have been released, but he's there, and the other client
now for he's
okay.
Okay.
Is there a number I can call the jail?
It's 404-612-2392.
And then that is unstable.
And
All right.
sitting before the judge is position 36, Tuggle.
Okay. Thank you.
And Your Honor, when you finish with the private attorneys, I have one private attorney, Mr. Samuel Real. His client is here, Ms. Hill, and she's position number 9.
Okay, thank you. Good morning.
You're welcome, thank you.
Your Honor, one more question, if I may.
Yes, you're fine. Go ahead.
As you know, I represent Michael Kirkland. I know that we're perhaps expecting him a little later. May I log off for 30 minutes to relocate? I'm on from the Cobb County Courthouse, and I'd like to get back to Atlanta. And then can I just take 30 minutes
yeah.
to get back and then log back out?
Yeah, that's fine. We'll be going for at least an hour and a half to 2 hours. So, so you're fine.
Okay, thank you.
Okay, I'll see you when you return. Thank you.
Yes, sir.
And unless I know that we have one other, I just want to make sure position number 1 is a private attorney also. Mr. Alford, is he in one of the courtrooms this morning?
I'm sorry, Judge.
I just wanted to know, I know that we also have a private attorney for position 1, Mr. Alford, and just wanted to know where he is this morning.
He's on 7.
He's on the 7th floor.
Okay, all right. So I don't know if counsel is present for him at the present time. All right, so this is position number 36, Mr. Tuggle. Good morning, Mr. McLean. This is going to be a negotiated plea.
Good morning. Yes, Your Honor, it is.
All right, very good. Good morning, Mr. Tuggle. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? You're on mute. Did you hear me, sir?
Yes, and good morning to you.
Thank you. Good morning, sir. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down, Mr. Tuggle. Good morning, Ms. Bacchus.
Good morning, Your Honor. The state's offer in this case is a 12 months, served 30 days, credit for time served, 16 days, balance probated, theft class, 20 hours of community service, no further contact with the, I guess, the owners of Luxury Real Estate LLC, and stay away from the incident location, which is 775 Jones Avenue. Nothing further. Well, I think we probably, for the 16 days, we'll probably do 32-16, if that makes sense.
Okay.
Okay.
32 days, to serve 16 days. All right. Mr. McLean, good morning.
Yes, Your Honor. So that would be no extra jail days and balance on probation. He would need to be on probation, however briefly, in order to get into, he would have to find and pay for and complete, and then prove that he completes the anti-theft class. And we've gone over that detail. 20 hours of community service, and that is our understanding of the negotiated plea.
Thank you. Any objection or termination when he's completed, Ms. Bacchus?
No, it can go non-reporting.
Okay. Does he have a history of theft?
He has, I'll be honest with you, he has 46 cycles but they're from 1976 to 2022. I only did the last 5 years. I don't see any theft in the last 5 years. Yeah, I don't believe so, Your Honor.
Thank you. Mr. Tuggle, it's my understanding that in case 22 CR 005630J, you wish to plead guilty to theft by taking, is that correct?
That's correct, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I will accept your plea as negotiated, Mr. Tuggle. I'm going to waive the probation fees while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Very well, and thank you again, sir.
You're more than welcome. You have a good day, Mr. Tuggle.
Thank you, Your Honor. I will scan into the scanner the paperwork he has already completed. He gave me permission to sign his name, and I will send that to the court.
Okay, yeah, Miss, if you can get all the paperwork to Miss Lewis this morning. Miss Lewis, are you with me right now?
Come on, sir. Are you there?
Yes, sir, I'm with you.
I want, on position number 15, Mr. Jeffries, I don't know if I said it or not, but I'm going to waive his probation fees as position 15, and it's going to terminate upon completion of the terms, okay?
Okay.
All right, thank you. Who do we have next?
Position 32, Taylor.
This is also a negotiated plea, Mr. McLean.
Yes, Your Honor. If
Good
it's
morning,
if it's middle first initial K, Taylor, right?
32, yes.
Carlise Taylor. Yes, that's it. Negotiated plea.
Thank you. Good morning, Mr. Taylor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor. Good morning, Your Honor. Yes, sir.
Good morning. Can you raise your right hand for me?
Yes, Your Honor.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down, Mr. Taylor. Thank you. Ms. Bacchus?
Yes, Your Honor. The state's offer in this case is time served. Stay away from the incident location at the Emory Hospital, 550 Peachtree Street, unless he has a medical emergency or some type of appointment. I'm trying to pull up my Odyssey right now to give you the exact days. So if you could just bear with me on that.
Okay. Mr. McLean?
Your Honor, that is correct. That's the correct, it is time served.
Okay, we'll need to, as Ms. Bacchus understands, we'll need to know how many days to give him credit for.
Oh, let's see, if he's been in since the 11th, that would be quite a bit. Let me find somebody that's
For
been in
about
since.
15 days. As of today, it's been 15 days. He's been in jail since August the 23rd.
Okay,
So 30-15.
all right. Mr. Taylor, it's my understanding that you wish in case 22 CR 0056666E to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced you to plead guilty?
No, Your Honor.
Okay, I'll accept the plea as negotiated, Mr. Taylor. Good luck to you, sir.
Yes, Your Honor.
Thank you.
All right, and number
Position
33,
26, Price.
no, 33, Mr. Taylor.
Okay, we're gonna go to 4 North. And I've got that Mr. Taylor's case was supposed to be reset because he's gonna be on the competency calendar. Is that incorrect?
We haven't done the paperwork, but when I interviewed him, it was clear and obvious that he needs to be on a competency calendar.
Okay, so he's gonna be placed 4 North. He's gonna be placed on the next competency calendar. Do we know when that is, Ms. Lewis?
September the 15th.
Okay, on September 15th.
Okay.
All right.
Yeah, 13
Thank you,
and
4 North.
13, 14, Mr. Jacobs.
I'm sorry, say it again for me.
13 and 14, Mr. Jacobs.
Okay. Mr. Jacobs, this is, I believe Mr. Ford's client, and Mr. Ford is interviewing people right now. Can we go to someone else until Mr. Ford is available?
Yes, Your Honor, the South Annex, position number 9 for the private attorney, Mr. Real.
Let's see. Mr. Real on?
Good morning, Your Honor. I'm here.
Good morning. What are we gonna do with Ms. Hill this morning?
Well, The only offer I've received currently, and haven't had much conversation with the prosecutor, was 1 year to serve. So I have filed a motion for a jury on it. On the other hand, if the prosecutor is willing to do time served, I think we could dispose of this matter.
I would defer to ASG Walker in that request.
I'll be glad to have a breakout or a phone call, but it will not be time served.
Okay, well, why don't I do this? Why don't I just go ahead, Ms. Rail, it doesn't appear that there's going to be a negotiated plea today. If you want to file I could either arraign her this morning, or you can file a written waiver of arraignment. And while she is, and then you'll have the opportunity to speak with the solicitor's office as the case moves forward. Is that what you want to do this morning?
Precisely. We'll file a written notice here of waiver of arraignment, and then we'll proceed accordingly.
Okay, very good. Is that your only case on the calendar this morning?
Yes, it is, Judge.
Okay, you have a great day. And if you can get that waiver to the court as soon as possible, we'd appreciate it.
Certainly will. Thank you.
Okay, very good. Have a good day. Who do we have next?
Position 26, Mr. Price.
Good morning, Mr. Price. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Price. Ms. Bacchus?
Yes, Your Honor. The state's offer on this case is 12 months, 120 days to serve, credit for time served, 9 days. I'm going to check that 9 days because that may have been before the holiday. Balance probated, 12 weeks of anger management, 40 hours of community service, no further contact with the victim, Sanders Love, and stay away from the incident location, 2939 River Ridge Drive. No alcohol, drugs, or weapons.
Mr. McLean?
Your Honor, that is the negotiated plea, and he understands. Now, the 2939 is directly across the street from 2938, which is his residence. So,
Your Honor, it is. My apologies.
He understands that it is a fine line in staying away, and he will stay away.
Okay. Mr. Price, it's my understanding that in case 22 CR 005650H, you wish to plead guilty to battery. Is that correct? Courtroom 2. Thank you.
Sir.
Is that a yes?
Yes, sir.
Thank you. Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Price. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. But you're going to have to be on probation for the entire 12 months, okay?
All right.
All right, very good. Good luck to you, sir.
Thank you, Your Honor. I told him also that assuming the 2-for-1 feature, that he would be out approximately October 21.
Okay.
How much time to give
Your Honor?
for 15 days?
Yes, Ms.
Yeah,
Fox.
that's what I was going to say. It's
Yeah,
not 9, it's 15.
Okay. Credit for time served 15 days, Mr. McLean. All right, who do we have next?
Position number 29, medical.
I would like to Signature bar.
This is going to be a, an arraignment, Mr. McLean.
Number 29, Timothy Rutledge. Let me look in my thing here. Not guilty bond request from our side. Right.
Signature bar.
Good morning, Mr. Rutledge. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. You agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony about, keep it raised for me, Mr. Rutledge. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir. But can I add something, sir?
Okay, put your hand down first, Mr. Rutledge, and let me just tell you that you have a right to remain silent. Anything you say can and will be used against you. You have Mr. McLean here as your attorney speaking on your behalf today. Quite often, people think that what they say might help them and it might not. But if you would like to speak with Mr. McLean, I'm happy to give you that opportunity.
Yes, sir, I would.
Okay, Mr. McLean, did you hear that?
Yes.
Okay, before he wants to speak with you before moving forward. So if we can put Mr. McLean and medical into a breakout room and go back to Mr. Ford's cases while they speak.
Yes, I can do that.
Okay, thank you.
Because they gotta go meet him and I don't want them to, you know.
Okay, so do we have one of Mr. Ford's clients that we can take?
Yes, position 16, Goodwin.
Okay, thank you.
And Your Honor, that's on your, it might be Jeanette.
Yes, sir.
Yes.
Okay, yeah, he has an alias, so it is Goodwin, but also goes by Jeanette.
Okay, so it's Justin Brian Jeanette. It's what I have on my.
Yeah, same person, yes, but in the jail they have him down as Goodwin.
All right, so what is the issue? I have something about a new case.
Yeah, I buried my sheet, Your Honor. I apologize, it's here.
Yes, Your Honor, it's 22 CR 005722.
Yes, Your Honor. My client is asking that if he pleads guilty today to one criminal trespass, he has a new criminal trespass, which is case number 22 CR 005722. And he also like to have that be concurrent or dismissed with this case.
The state will be okay with doing a global resolution in that case and resolving both cases today.
Okay, can you put on the record what the offer is for a global resolution? And
That's disposition 9. No, it's not. 16. It is 12 months to serve, 12 days credit for time served, 12 days with the balance suspended, and a stay away from the incident location. For count 2, the obstruction is no pros. So he would serve 12 months to serve, 24 days credit for time served, 12 days with the balance suspended for both positions. Do you need that case number again, Your Honor?
I have it. So he's going to plead guilty to 2 criminal trespass charges, the 6106Y case and the 5722 case.
That's correct, Your Honor.
Okay, all right. Is that your understanding, Mr. Ford?
Yes, I do, Your Honor, and I will prepare a separate plea sheet for the new case, Your Honor.
And I just want to make sure that there's a stay away condition on both of the cases.
All right, you want to give me the stay away or?
I'll leave that to Ms. King.
Okay.
Yes. One moment, Aaron, let me pull it up. It is a Kroger. Let me get that address.
And to let you know that his other case was was on for Thursday calendar, so.
Okay,
It is 1715 Howell Mill Road Northwest. And that is a Kroger.
was that on both cases or just one?
The incident location for the case before your honor is 630 10th Street Northwest in Atlanta. And that's a quick trip.
That's the present case, am I correct?
That is correct. And the first one is for the 722Y case.
And where was the stay away location on the 722Y?
It is the Kroger located at 1715 Howell Mill Road Northwest in Atlanta.
Okay, I'll
All right.
prepare the paperwork for that as well.
Okay, so he understands he has to stay away from that Kroger and that Quick Trip.
Correct, Your Honor.
All right. Are we ready to take the plea?
Yes, Your Honor.
You have something, Ms. Lewis?
Just want to clarify the plea altogether. I heard her say 12 months to serve 12 days, and then she said 24 months to serve
No,
12 days.
it's gonna be 12 months to serve 24 days, credit for time served 12 days, balance suspended is my understanding,
Correct, Your Honor.
with the 2 stayaways.
I was just giving him the 2-for-1 credit, Ms. Lewis.
Okay, and just send the null process to me in the email. I appreciate that.
Yes, ma'am, will do.
Okay, are we ready to take the plea?
Yes, Your Honor.
And I don't know if I've already addressed Mr. Jeanette. I don't think I have. Good morning, Mr. Jeanette. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I do, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down, Mr. Jeanette. It's my understanding that in case 21 CR 006106Y, you wish to plead guilty to criminal trespass, and in case 22 CR 005722, you wish to plead guilty to criminal trespass. Is that correct? Is that correct? Are they frozen? Is courtroom 2 frozen?
Yeah, we froze for a second, Judge.
Okay, thank you. Mr. Jeanette, did you hear my question before you froze?
Yes, sir, I did. I understand you.
And you wish to plead guilty to those 2 counts of criminal trespass, is that right?
Yes, sir. Would it be credit time served?
It's gonna be time served, yes, sir.
Okay. Thank you, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Absolutely.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Jeanette. You know you can't go back to that Kroger and you can't go back to that Quick Trip, right?
Yes, sir.
All right. Good luck to you, sir.
Thank you.
Your Honor, I just have to have a question of Mr. Jeanette for a moment. Being that I will be doing a separate plea sheet for the second criminal trespass, do you give me permission to sign for you, Mr. Jeanette?
I do, sir. You can sign for me.
All right, thank you.
Okay. Are we gonna go back to medical?
Yes.
All right. And tell me again, Mr. McLean, what position is this?
Position number 29.
29, thank you. Okay, Mr. Rutledge, we've given you the opportunity to speak with your counsel. You've already been sworn in. Mr. Rutledge, in case 22 CR 005631J, you've been accused of 2 counts of criminal trespass. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine.
Yes,
Do you
sir.
waive formal reading of the accusation, Mr. McLean? You're on mute, Mr. McLean.
We can waive that, Your Honor. Yes, thank you.
How do you plead to these charges, Mr. Rutledge? Guilty or not guilty?
As of right now, if I just want to hear if you give me a signature bond, but right now,
Okay,
not guilty.
hold on. We're not addressing the bond right now, Mr. Rutledge. I just need to know whether you want to plead guilty or not guilty to these two charges at the present time.
I mean, after I hear your decision on what I'm trying to do, I might plead guilty, a non-negotiated guilty plea, because they're actually trying to offer me too much
Hold
time.
on, again, Mr. Rutledge, hold on now. So let's handle one thing at a time. So it's my understanding that you want, I'm gonna address your bond. I'll give you that opportunity, but right now I need to complete this arraignment. So do you plead guilty or not guilty? I'll give you if you hear my decision and you want to change your decision at some point in the future, that'll be fine. But right now, it's my understanding that you're going to plead not guilty to these charges. Is that right?
How long is that going to take, sir, in the future?
I'm gonna hear from everyone right now. So I'm not going to let you go anywhere until I hear about the rest of your case. Okay?
Okay, not guilty. You said
All
what?
right. It's 2 counts of criminal trespass, Mr. Rutledge. It's my understanding that you're pleading not guilty to those. Is that right?
Yes, sir. And I'm asking for a bond, a signature bond.
Okay. So we're gonna go to that right now. So I can't decide about the bond until I hear more information about your case. Okay?
Okay. But can I ask one more question?
Hold on. So let me hear about your case. And I'm gonna start with hearing about your history. So, Ms. Harrison, does Mr. Rutledge have a history?
34 cycles, last arrest July of this year for simple battery and criminal trespass in Fulton County. Record indicates an open probation for simple battery, criminal trespass. Sentenced August of this year, 12 months probation in Fulton County. Record also indicates an additional open probation in Fulton County for possession of marijuana less than an ounce, possession of methamphetamine, possession of Schedule I controlled substance. Case number 20 CR 01905, sentenced November of 2020, 5 years probation. That is open probation in Clayton County.
And Your Honor, just to add to that, there's one additional case I did not hear. 22 CR 003447J. That is a suspended sentence from this year. Guilty conviction that also occurred in MARTA, and the condition of that sentence was a stay away from all MARTAs. In short, I'll let Ms. Bacchus take this, but this is the defendant's 3rd case at MARTA this year. 2 of them already being convictions. He has a suspended sentence. He has probation. The last case, I think he hit somebody in the back of the head with a beer can. I believe in this case, he kicked out a glass window. So the state is adamantly opposed from any bond reduction, seeing how he has 2 cases from MARTA and a stay away condition as it stands currently. So with that being said, he really needs to have a cash bond, but obviously we're against any reduction, any bond.
And it's my understanding that the current bond is $500 on each charge. Is that right?
More
That's
than
right.
Okay. And Ms. Bacchus, what is the offer in the matter?
12 months, serve 180 days, balance probated, MHET, and stay away from all MARTAs and comply with active MARTA suspensions. I am pulling up right now the days. One moment.
It'd be 16 days credit.
Okay.
That's correct.
All right. Anything? What do you want to tell me about the facts of the criminal trespass? I take it was at MARTA.
It was, Your Honor. It occurred on August 22nd. A MARTA officer witnessed the defendant kick the door to a MARTA bus that shattered the glass. And so, of course, he detained him upon running the information. That's when he found out that there was already, I believe, 2 active MARTA suspensions. And so those are the facts, Your Honor.
Okay. Mr. McClain?
Your Honor, upcoming in a couple of weeks, Mr. Rutledge has a Social Security Disability application hearing. He has designated his father as his representative. He wants to get the wherewithal to deal with his problems, and I think that will address any alleged behavior of this kind. If he is really anxious, super anxious about missing that hearing and throwing that months and months into the future. That's why he's asking for a signature bond. And of course, I would emphasize that he and I discussed the importance of staying away from all MARTA during any bond period that the court may grant him. And so he's saying, okay, I get it. Stay away from all MARTA. And if I get a signature bond, then I can get to my hearing. That's what he's anxious about.
Well, I understand that, but if he's already have a stay away from a plea that he allegedly didn't stay away from MARTA, I mean, how's that going to be any different than with with my bond ordering him to stay away? Is there an issue that I need to know about, Mr. McClain?
Well, he does have some issues for which he is applying for disability, and he's hoping to get into treatment for that. It's just basically the only thing I can say in response to that question would be just a newfound fervor, a newfound and
I don't have any transportation.
be sincere fervor about really staying away from all MARTA.
And Your Honor, it's not just been one case that he's been convicted on this year with MARTA, it's been two. And as I hear the defendant saying he doesn't have any transportation, that's indicative of, I don't have any transportation, I'll be back at MARTA. Two of these offenses were violent offenses. Like I said, the last time someone got punched in the back of the head, that was a simple battery. And now we have him kicking out a glass window. This is his third. I literally know Mr. Rutledge on a first name basis at this point. All of his cases have been at MARTA. So as you previously stated, what's the difference from if you were to give him a signature bond and he's already on probation and a suspended sentence with the stay away? So again, he has $1,000 total surety bond.
Sir, I can't make it because I don't have anybody co-sign, sir.
Considering that he's on
Okay,
probation.
hold on, Mr. Rutledge.
It's more than generous considering he's already on probation and a suspended sentence. I think both of the things were done in the last few months. So the defendant has made it clear that he doesn't care about what the order of the court is. He has defied it multiple times at this point. So the state is adamantly opposed to any reduction.
And Mr. McClain, is there someone that, number one, I'm not just going to put him out on the street. I don't know if he has a place to go. I would imagine that if there was someone here, there was someone that could help him, like his father or something that could vouch for him or something, then that would give the court some type of assurance. But just on his,
I do, sir. I have somewhere to stay.
I'm not going to put him out. Given what I've heard this morning,
sir, I have somewhere to stay.
Some type of assurance that someone's going to be
somewhere to stay. I have somewhere to stay.
Okay, Mr. Rutledge, Your Honor, if I could have a break to try once again. I have so far failed to reach his father by phone, but I'll try that again.
Okay, what I want to do, Mr. McClain, is that I want I'm going to put reschedule this for a week's time to give you an opportunity to speak with someone about Mr. Rutledge. If he has, as the state is asking for, some type of MH issue, then I want to know that too.
Yes.
I just don't want to put him out without helping him in some way. You understand what I'm saying?
Absolutely.
Okay, so what I am willing to do is put this on my calendar for next week, the SAP calendar, and come back and revisit Mr. Rutledge. If you can, or make an assessment, you can have a social worker go down and speak with him.
Right.
Because there seems to me to be some other type of issues going on.
Yes, sir.
Very
it is.
good. And Your Honor is correct. So that would be a good course.
Okay, so I'll see you again next week, Mr. Rutledge, if you can't make the bond, okay?
Okay.
Your Honor, he's being reset to 9:13.
Yes, that's correct.
Okay, thank you.
We got number 13 and 14, Mr. Jacobs next.
Okay, so, is this Mr. Ford's case?
Yes, it is, Your Honor.
All right, so on position number 14 is just going to be an arraignment, and he's gonna plead a non-negotiated plea to position 13.
That's correct, Your Honor.
All right, so why don't we go ahead and do the plea first, and then I'll take up the on the simple battery, and I'll take up the theft by shoplifting after that. Good morning, Mr. Jacobs. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Ms. Harrison, let me go ahead and get his history, please.
I'm showing 4 cycles. Last arrest was, one moment. May of 2021 for simple battery in Fulton County. No disposition listed on that arrest. Record indicates a 2017 conviction in Cobb County for entering auto. Nothing further, Judge.
Okay, so this is 2020. So this.
I'm sorry, it was theft by taking and entering auto, 2 counts each.
Theft by, is that 2027?
2000, the sentence was May of 2018 in Cobb County for entering auto, 2 counts, and theft by taking, 2 counts.
Okay, thank you. And so he had this 2020 simple battery, and he has another pending 2021 simple battery.
No, he has, no, just the one. That was the last arrest, May of 2021. No disposition listed on that arrest.
So I'm sorry. My
Yes,
calendar says September 20th, 2020, a simple battery, which is what we're here for.
And yes,
Okay.
the simple battery that pretrial brought up, yes, that's a second open simple battery out of College Park, Your Honor.
Okay, all right. Thank you. Yes, Ms. King.
So for position 14, the offer was 12 months to serve, 45 days, credit for time served, 16 days with the balance probated, 40 hours of community service, a stay away from the incident location and restitution in an amount of $82.98. The incident location is the Palmetto Package Store located at 510 Center Street in Palmetto. On April 9th of this year, officers responded to the incident location in reference to a theft by shoplifting. Upon arrival, they made contact with 2 females that worked for the store. They said that he came into the store and grabbed alcoholic beverages, a bottle of Don Julio, $50.99 a bottle, and Terramana Blanco, $31.99, which brings the total to $82.98. The officers also saw video footage of the incident of the defendant taking possession of these alcoholic beverages.
Okay, so I'm sorry, Ms. King. It's my understanding that he's going to plead not guilty to the theft charge. I need to speak on the simple battery charge.
Oh,
Yes,
my apologies.
Yes, I was going to
So-
object to that statement because we're only here for the simple battery.
My apologies. So for that one, that is a, let me see what the announcement was, 15, non-negotiated. My apologies. That offer in that case is 12 months to serve, 45 days credit for time served, 16 days with the balance probated, a stay away and no further contact in the 6-week anger management course. He'll be staying away from Cleveland Avenue in Atlanta, and the victim, no, that is the wrong, my apologies. Stay away from the Waffle House located at 4995 Old National Highway in College Park, and the victim in that case is Meshawn Fitzpatrick, Meshawn, last name Fitzpatrick. This offense occurred on September 24th of 2020. And officers responded to the incident location. They had gone there after leaving a lounge, and people started to crowd in the parking lot. This is what the employees of the Waffle House said. Then they came inside and began to order their meals. And when they came inside, that's when it started to escalate between the parties that were once gathering outside. When the officers pulled them away to kind of see, a bystander pulled them away to kind of see what was going on, and the defendant threw hash browns, hitting the victim in the face. At that point, officers were called and he was detained.
Okay, Mr. Ford.
Thank you, Your Honor. Your Honor, we're asking that the jail time be reduced to time served. Due to the fact with the 45 days, they're asking for my client to do one more week in jail, but I think he's done sufficient time for this simple battery. As you'll look at the report, Your Honor, my client is taking responsibility for the incident as far as the simple battery itself. But as you will note in the report that there was exchange of words between both parties. So there is some fault, I think, on the part of the complaining witness, but my client is taking responsibility for the simple battery at this time. So we're asking that the 45 days be reduced to 32 days, Your Honor. That would give my client time served. At this time, my client is also asking that we reduce the 8 weeks of anger management to a one-day anger awareness class. He is concerned about the fact that he will not have employment to pay for 8 weeks of anger management due to the fact that due to his kind of incarceration, he believes he's lost his job. So at this point, Your Honor, I think once again, it sets him up to fail. He needs to find employment so he can pay for any courses, but I feel a one-day anger awareness class and time served would be appropriate. My client does have a stable address, Your Honor, and he's been in Georgia all his life. I know it's not a bond hearing, but I think that's information I'd like to share with Your Honor at this time, Your Honor.
Your Honor, if I may, the time is absolutely appropriate due to the defendant re-offending multiple times. He even has an open felony case, 17 SC 154192, which shows the defendant is not listening to the court's orders, and he's violent to the citizens of Fulton County at large, Your Honor. Due to that, the time that the state is seeking is more than reasonable, and the anger management is absolutely necessary due to him having so many violent offenses in a short period of time.
What is the felony, Ms. King?
Is an obstruction, a felony obstruction, Your Honor.
And Your Honor, besides that, I heard PD4 say that there was an exchange of words. Let me be clear that this was a female victim. So for you to sit here and victim shame and say and justify that your client put his hands on a female because he didn't like what she had to say is absolutely inappropriate. I don't care what that young lady said. At the end of the day, he hit a woman in the face with a plate of hash brown, and he is a grown man. So to sit there and say, oh, there's an exchange of words, so therefore there's some type of fault on her end is absolutely unacceptable.
Well, Your Honor, and I don't want to challenge, and with all due respect
Because
to
you can't.
Walker, it was quite present in the report that there was some exchange even from.
Words were exchanged and he hit a woman in the face.
However, I let you speak, Mr. Walker. I just like to have a minute just to clarify. And so at this point, my client is taking responsibility for that.
But
I
you
just
said there was some fault on the end of the victim, which is unacceptable.
I didn't say it was the fault.
Yes, you did. Yes,
I
you
said
did.
exchange of
All
words.
right. This isn't helpful.
It's up to the judge to determine if there was fault. But I said exchange of words that led to my client committing.
It's okay.
So at this point, Your Honor, we're asking for time served and the 1-day anger awareness, Your Honor.
Okay, so he's gonna.
And a NOLO, Your Honor. We're asking for a NOLO as well.
I'm not gonna allow him to plead NOLO. The state is asking, it's my understanding, for 6 weeks of anger management, not 8 weeks. Is that right, Ms. King?
That's correct, Your Honor. It is 6 weeks.
All right, so what I'm gonna do is I am I think 16 days is sufficient. He's gonna have to do the 6 weeks of anger management. He's not gonna be able to plead NOLO. He's gonna have to plead guilty, and he's gonna have to stay away and have no further contact. I'm gonna waive the fees, and once he's completed, it'll go to a non-reporting status. So that's what I'm gonna do. Is that what he wants to accept, Mr. Ford?
Did you hear the offer? I mean, what the judge is recommending that he's going to do? Are you okay with that, Mr. Jacob?
Yes, sir.
Okay,
Yes, sir.
then we'll proceed with that, Your Honor.
All right, so Mr. Jacobs, it's my understanding that in case 22 CR 005624J, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. Jacobs. The sentence is going to be 12 months to serve 32 days, credit for time served 16 days, the balance probated. You're to have a 6-week anger management class, no further contact with the victim, stay away from the Waffle House, no drugs, alcohol, or weapons while on probation. I'm going to waive the probation fees for you to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay? All right, so let's move on to case 22 CR 005625J, the theft by shoplifting. This charge carries with it, Mr. Jacobs, a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead to this charge, Mr. Jacobs, guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. What's the current bond on this charge?
It is a $1,500 surety.
And I understand that he does have 2 thefts by taking in the past. So, Ms. King?
Yes, that is correct, Your Honor. He's also being held on no bond on that felony case I referenced earlier. The $1,500 surety is more than reasonable due to the defendant's criminal history. There is a likelihood he will reoffend because he has reoffended, Your Honor. So the state is requesting that a $1,500 surety remain in place as well as the conditions.
Okay, Mr. Ford, given that he's on a no bond on another case, I'm going to leave the bond where it is at the present time. If he makes bond on another case, I'm happy to hear a modification in the future, okay?
That's fine, Your Honor. We were hoping to do it the other way to get a better bond for him. And then once he got on the other case, he could walk, but that's okay, Your Honor. We'll do it that way.
Yeah, he's got bigger fish to fry than this, so.
I understand.
All right, good luck to you, Mr. Jacobs. Who do we have next?
Position 8, Hall.
Good morning, Mr. Hall. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down, sir. Ms. King?
Your Honor,
Yes.
excuse me,
Yes.
Mr. King, just for a moment. My client has brought to my attention that he has 3 other charges that he felt were misdemeanors, Your Honor, and he felt the last time he was before you that there was supposed to be some type of global resolution of all his charges. I do see, I won't announce the one charge, but a public drunkenness and a terroristic threat and another case, Your Honor. If those are all misdemeanors, he would like to have those resolved at one time. And I did put a call into Mr. Walker, and I apologize for the short notice on it, but I did put a call in asking to see if all 3 of those charges were.
I checked the jump screen, but those other charges were felonies, so I'm not sure if that's what he was referring to.
Yeah.
But he's on 3 felony charges.
Yeah.
With no
Well, thank you for that, Mr. Walker, because I did let my client know that when I looked at the screen that I saw that at least one of the charges was a felony, so it could not be resolved today, but he thought they were misdemeanors, so I thought that would bring that to your attention.
Yeah, no, from my understanding, those other outstanding charges are felonies and it has a CP number, so I think that's what he's talking about.
Yes, it is. I have it pulled up myself. Did you hear that, Mr. Hall? So, are you prepared to proceed with the case before us today? What's that?
I was on pre-trial for the 3 charges, and I have a hold on them. And from my understanding, that was misdemeanors when they gave me the signature bonds back in January. And I had to bond out on 1 felony, which I did.
He has
Pre-trial surrender that bond with this new arrest. That bond was surrendered.
Is there a way can I get reinstated from pre-trial bonds?
No.
That would be up to Superior Court anyway. I mean, this is state court. Those are felony charges.
And what's happening, Mr. Hall, I don't want you to say any more because I think it's clear that either you got to deal with the misdemeanor today or you can wait for the other cases, which are felonies, to be dealt with. We talked about that at great length.
Is there a way can I get a bond today?
Yeah, you can plead not.
Not for the other cases. He can't.
Yes.
The Superior Court cases, of course, he can't get a bond in this court for.
But you can get a bond. We can ask the judge to modify the bond that you have presently on the present case, if you'd like.
He already got a signature bond on that charge that we're addressing today.
Oh, well, there's nothing much else we can do, Mr. Hall, but either you're going to plead or you'll plead not guilty and move on.
So the 3 charges I have, they're felony cases?
Yes, that's my understanding.
We
Mr.
checked it
Hall.
out.
The other cases are felony cases.
I think the defendant doesn't understand that when they're in the same incident, if one of them are felonies, they all go up because Superior Court has jurisdiction over felony and misdemeanor. So while 3 of the charges may technically be misdemeanors, Superior Court has jurisdiction over all of the charges because they're under the same case.
Do you understand that, Mr. Hall?
No, I don't.
Okay, good. Thank you, Ms. King.
So when will I go to court for these charges?
Well, that's not for this court to deal with. Those are in another court, Mr. Hall.
All right.
Are you prepared to go forward with your criminal trespass and damage to property? Because it is time served. balance, and no probation?
Yes.
Okay, thank you.
All right. Can you raise your right hand for me, Mr. Hall? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Ms. King?
Yes, Your Honor, the offer is 12 months to serve 60 days, credit for time served 30 days with the balance suspended, and a stay away from the incident location, which is the Pals Lounge, PALS, 254 Auburn Avenue in Atlanta.
Mr. Ford?
Yes, we do. We concur with the recommendation of the state at this time.
Mr. Hall, it's my understanding that in case 22 CR 005276G, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the guilty plea as negotiated. Good luck to you, Mr. Hall.
Oh, sir, when am I going to court date for my other charges?
You'll have to speak with somebody in Superior Court regarding when your next court date is in that matter. Okay?
Okay, thank you.
All right. Who do we have next?
Position 7, Grooves.
Good afternoon, Mr. Groover. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Sir, yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir, yes, sir.
Okay, you can put your hand down. Thank you, Mr. Groover. It's my understanding, Mr. Ford, that this is going to be a non-negotiated plea.
Yes, Your Honor, the only issue here is that we're asking for it to be balance suspended. The only term that the solicitor is asking for is an evaluation, and we're asking that my client just be done with this case.
Yes, Your Honor. The state is asking for probation while the evaluation takes place so that we can ensure that the evaluation in fact does happen. The state will be okay with consenting to probation terminating once the evaluation is completed.
Okay.
Your Honor, if I may, my client is not working. He has, I don't believe the evaluation, basically he's already done 8 days in jail on these obstruction and reckless, obstructing in a highway or passage and reckless conduct. Your Honor, my client does not work. And at this point, we're asking, and he's a lifetime resident, 41 years old. Your Honor, we're asking that this case be resolved today with a balance suspended.
So you're disagreeing with the MHET is what you're disagreeing with, Mr. Ford.
Yes.
And we might need to go to a breakout room because obviously there's sensitive matters at play, but there's a sufficient basis to say the least as to why we're requesting the evaluation. So
Agreed,
I don't know if we want to discuss this in open court or we can go into a breakout room, but I'll be glad to articulate to the court.
I don't want to discuss this in open court, Mr. Ford.
All right.
So if we can go into a breakout room with Ms. King, Mr. Walker, Mr. Ford, myself.
Hey, Officer Matthew.
Yes.
Ringo is not on 3 South. He was moved. So I'm not sure where he is, but it's still showing an odyssey that he's on 3 South. Can you check and see if he's on the 4th floor while you're up there?
You said Wingo?
Yes.
All right.
First name Eric.
Okay, we've had a discussion regarding Mr. Gruber. If Mr. Gruber continues to want to enter into a guilty plea, the state's recommendation will be accepted, which is a time served, which will include the MHET. And once that evaluation has been completed, then the probation will terminate. Is that what your client wants to accept, Mr. Ford?
Mr. Groover, you have heard that the MHET evaluation is going to be required by the judge for you to plead guilty. And then after you complete the evaluation and treatment, then your probation will be terminated. Are you prepared to proceed?
I'm prepared, sir.
All right.
Okay. Thank you. If nothing further, Mr. Groover, it's my understanding that you wish to plead guilty in case 21 CR 006271B with obstructing highway, a street, sidewalk, or other public passage, and reckless conduct. Is that correct?
That's correct, sir.
Are you under the influence of any drugs or alcohol at the present time?
Sir, no, sir.
You've been represented by counsel. Are you satisfied with his representation?
Sir, yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I understand, sir.
Has anyone forced or coerced you to plead guilty?
Sir, no, sir.
I will accept the plea, and the sentence will be as stated. Good luck to you, Mr. Gruber.
Okay, so that means I go home today, correct?
Yes, it's a time served plea, Mr. Gruber.
Thank you very much.
And you will be on probation. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And once you complete the terms of the probation will be terminated, okay?
Yeah, I have a newborn baby now, so I have a son, and I've been doing good, sir.
Okay, congratulations, Mr. Gruber. Good luck to you, sir.
Judge, can you please go over that plea again?
Your Honor.
Okay, it's going to be it's 12 months to serve, 16 days, credit for time served, 18 days, balance probated to complete the MHET, and the probation will terminate once the MHET is completed, and I'm waiving the fees.
That was 8 days. I think you said 18, but it was 8 days.
Oh, okay. Thank you, Mr. Ford.
It's okay.
Who do we have next?
Position 19, Kirkland.
22, Mr. Milo.
Hold up, Matthew, this is the guy that we had earlier today from Mr. Sharp, from Max Sharp, Your Honor.
Mr. Milo.
Okay. Let's see. I saw Mr. Short back on the line with us. Oh, there you go.
I'm here, Judge.
What are we doing with Mr. Kirkland today?
I have discussed this matter with the state. There are some possible defenses, but I would like, and I think Mr. Kirkland would like to proceed with a plea. But Your Honor, I have to ask one question because there's felony probation involved in this. We can only enter a plea today if Your Honor would be open to accepting a no contest plea. That's otherwise, I just don't procedurally, I don't believe we're in a place that it would be wise for Mr. Kirkland to enter said plea.
Does the state have an objection to a no contest plea in these charges?
Yes. Yeah, we have a objection to the no contest plea at this time.
Is that because of the history?
That is correct, Your Honor.
Okay. May I hear the history, please, Ms. Harrison? And Ms. Harrison, I don't know if you're speaking or not, but if you are, you're on mute.
Sorry about that, Judge.
That's all right.
19 cycles, last arrest December of 2020 for probation violation in Fulton County. Underlying charge is aggravated assault. He's currently on probation for aggravated assault in Fulton County. Aggravated assault with a deadly weapon, 2 counts, criminal damage to property and possession of a firearm or knife during the commission of a felony, 16 SC 146977, sentenced January of 2021, 60 days confinement, 4 years, 10 months probation. Additional open probation for disorderly conduct, 19 SC 172316, sentenced August of 2021, 12 months probation. Additional open probation in Cobb County for possession of Schedule 4 controlled substance, case 1894178, sentenced December of 2019 with 3 years probation. Record indicates 4 failure to appear and 5 violations of probation within the past 10 years. Nothing further to add.
So for both of these, it would be a time served plea. For all 3 of these would be a time served plea.
That's correct.
And tell me, Ms. King, the facts regarding the criminal trespass and loitering and prowling.
Yes, Your Honor, this offense occurred on April 10th of 2019. Officers were dispatched to a suspicious person's call at the A&K food store located at 1981 Joseph E. Boone Boulevard, Northwest in Atlanta. This area is known for high crime and frequent drug activity. So when they arrived, they noted individuals distributing narcotics, which is popular for this area, and they were not patronizing the business in any way. So they went and detained the individuals and were speaking with them and notated that one of them were the defendant in this case. And that officer was actually involved in a previous arrest for narcotics at the same exact location where he was told not to return to that location. In that case, he was charged with possession of marijuana with the intent to distribute and also conspiracy. I'll also like to note that the employees of that location also told this defendant to not return, and he was also officially criminally trespassed from this location. At that point, he was arrested, and search incident to arrest, they found marijuana in the defendant's crotch, which further bolsters why the officers acted the way that they did in this case. A NOLO would not be reasonable under any circumstances in this case due to his open cases, some that were subsequent to this arrest, Your Honor, and also his pending felony cases.
Okay, and the loitering and prowling, was that at the same location?
That is correct. That's what they were originally dispatched on, but once they got there and determined who the defendant was and his criminal history and everything kind of, opened up from there. But yes, that was where it started.
Has he been in jail in custody for 72 days on just these charges?
No, Your Honor. He's also being held on the 22 CP case, 211166, which is providing firearm to a felony first offender and other charges. The aggravated assault predates this, but he also has FTAs out of Cobb, which he will have to answer to as well, because he has he has 2 open cases currently out of Cobb.
All right, and just so I'm clear, what, Ms. Harrison, these charges are from 2019. What was his history prior to 2019?
One moment. October of 2019, he had an arrest for possession of cocaine. He had a failure to appear, separate arrest. 2019, violation, 3 violations of probation, another failure to appear in 2018. A 2019 possession of marijuana less than an ounce and possession of Schedule 4.
And that possession, what happened with that charge?
That was a conviction. That was in Cobb County. And he has a 2016 cruelty to children in the 3rd degree. That was a conviction in Fulton County. A 2017 possession of marijuana, that arrest was no pros. A 2016 criminal trespass, no pros, Fulton County, both of those. And that's it, Judge. He has a 2014 for carrying, one moment, 2015 possession, one moment. His first arrest was in 2014 for carrying a weapon without a license. No disposition listed on that arrest.
And FYI, his co-defendant on the marijuana case was convicted of manufacturing and distribution of marijuana, but that case was handled by the DA's office.
Okay, Mr. Schwartz, anything you want to say?
Well, Your Honor, I obviously dispute some of those allegations. There's obviously going to be issues with the criminal trespass notice, and I'll also point out that while this arrest was 2019, our jurisdiction is not even actively prosecuting possession of marijuana at this point. So I think that should be taken into account as well. Mr. Kirkland is a young man who I've been tasked with cleaning up a lot of the mess that he has made for himself. And we are going to go to Cobb County and we're going to deal with Fulton County Superior Court. But as his attorney, I just can't advise him. I believe that this should be a time-served plea. I don't believe that he's hanging out on Simpson Road anymore. But just procedurally, while I understand the state's position, I don't think it's in his best, I don't believe it's in his best interest to enter anything other than a no contest plea at this time. So we'd ask that you would consider that, especially since these incidents are from 2019 and he will not be released today. He has other holds that we're going to have to address in Fulton County as well as Cobb County.
And if he pleads guilty, it will affect his status of his probation. Is that what you're telling me?
It is his 2016 probation. Yes.
Okay. Given the date of these and what I've heard regarding the prior history, if he wants to plead guilty today to all 3 counts, then I will allow him to use a NOLO on these charges.
Your Honor, the state would like to renew its objection to a NOLO plea due to this defendant's criminal history.
Okay, thank you, Ms. King. I note your objection. I think that Mr. Kirkland is going to have bigger fish to fry than this, and I would like to move this case on, these cases on, and take a plea on them if that's what he's willing to do.
And I've discussed this possibility with Mr. Kirkland. Ms. Kirkland, if you could give me a thumbs up to let me know that you wish to proceed. Okay.
Okay.
Just give me a thumbs up.
All right. So let me start from the top. Good morning, Mr. Kirkland. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Good morning. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Kirkland, it's my understanding that in case 19 CR 0034488A, you wish to plead no contest to possession of marijuana less than an ounce in criminal trespass. And in case 19 CR 007274A, you wish to plead no contest to loitering and prowling. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading no contest to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead no contest?
No, sir.
I'll accept your pleas. The sentence is going to be 12 months to serve 72 days, credit for time served 72 days, balance suspended. Good luck
And the
to you,
stay
sir.
away, Your Honor.
Okay, tell me the stay away again, Ms. Kane.
It is from the A&K Food Store, 1981 Joseph E. Boone Boulevard, Northwest in Atlanta.
Okay, and stay away from that location, Mr. Kirkland.
Well,
All right. Good luck
Thank
to
you,
you,
Your
sir.
Honor.
You're welcome.
Stay away for both of the charges? For both of the
That's
cases?
correct. Yes, it's the same incident location for both positions.
Okay.
All right, thank you.
I just sent you the plea paperwork. If you can please complete that information, email that to me in a timely manner, I appreciate it. Just check the email, I sent you the plea paperwork.
All right, so as we get that done, who do we have next?
Position number 4.
Can we do position number 5? Cause he get irritated up here. We have to
Okay,
take
tell
it
me,
back.
what position is it? Tell me again.
Position 5, Mr.
Five.
Frank.
Mr. Crane, okay. Good morning, Mr. Crane. I'm Judge Eric Morrow. This is the state all-purpose calendar. We're holding this by video. Do you agree to have your case heard by video?
Judge, this is the guy that's called a hearing
Oh,
from last week.
so if he couldn't hear last week, can he hear this week? I mean,
I doubt it.
So the discussion that I had with PD Finley was that the social worker was going to go out to speak with him to discuss some placements. Cause I will null process the case, but it doesn't appear that the defendant is in any shape just to be released to the streets haphazardly. So I don't know, the social worker went and spoke to him. I don't know, Mr. Ford, if you can look into it. But
Your Honor, and thank you, Mr. Walker, but I thought this case was going to be null pros. That's what it was. The offer was sent over as a null pros. I had informed my client that his case it appears going to be dismissed without any.
That was the agreement that I had with PD Finley. I'll submit the null pros. As you see, the man is in medical. You weren't here last week. He doesn't appear to be well, and we believe he's homeless. But I'll submit the null pros, and if you're comfortable with it, let your client go off into the wind.
Yeah, I'm not throwing caution to the wind. It's just that I have presented your offer to.
Right. It was further conversation with me and Mr. Finley, but we'll leave it. We'll leave it there.
All right. Thank you.
all right, his case is going to be null pros. Thank you, medical.
I'm sending it
Who do
over
we have
now.
next?
Number 22, Mr. Miles.
What number are we on, Your Honor?
22, Malam.
All right. Thank
Milam?
Milam, is that Ford North? Is that you, Mr. Milam? All right, good morning, Mr. Milam. I'm Judge Eric Morrow. This is the state all-purpose calendar. Doing fine, thank you, sir. We're conducting this calendar by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so this is non-negotiated, Mr. Ford, jail time and no further violent contacted issue, or no further contacted issue, is that right?
That's correct, Your Honor.
What's the history on this case? For Mr. Milam. Ms. Harrison.
Six Cycles, last arrest, April of 2020, for aggravated assault in Fulton County, 3 counts. That is an open case, 20 CP 190987. Record also indicates that's it, Judge. Nothing further.
Okay, Ms. Bacchus.
Your Honor, I would like to clarify based on the GCIC that I have, it looks like he has 8 cycles. And he also has subsequent a case to this, which is, I will pull up the case number. I don't have it right now, but it looks like it's felony criminal attempt to commit ag assault, theft by shoplifting, possession of a firearm during a felony. And that date of incident is 5/2022. The state's offer on this case was 12 months, 120 days to serve, credit for time served, 9 days, balance probated. The FVIP, no further contact with the victim, Miss Kaylecia Wilson. Kaylecia is spelled Kaylecia, Wilson, common spelling. Stay away from the incident location of 183 Mount Zion Road Southeast, and no alcohol, drugs, or weapons. Your Honor, this incident occurred back on January 14th of 2021. An officer was dispatched to that incident location in reference to a domestic dispute. Upon arrival, the officer spoke with the victim, Ms. Kaylecia Wilson, who said that her and her live-in boyfriend, the defendant, got into a verbal dispute that escalated into a physical fight after she told him to leave the location. She told the officer that once she told him to leave, he began throwing and breaking items in the house. He struck her in the face, causing her nose to bleed. Ms. Wilson told the officers that she had thrown some glass at him, but it didn't strike him. Then he took her phone and he left the scene. The officer did observe that Ms. Wilson had a bloody nose and a lip laceration, and that there was blood throughout the apartment. Your Honor, our real concern with this is that even though this happened over a year ago, the no further contact is appropriate in this situation because the officers then got a stabbing call 10 minutes later, and the victim in this case actually stabbed him. He had to be rushed into surgery. And while they were observing the victims, in this case, her wounds, taking pictures, the toddler in the case walked out into the living room with a handgun in hand that they ran, and it was stolen. And so there is serious concern about them dealing with each other at all, even with the cool down period. Based on the history, based on the fact that there are ag assaults and other battery family violence from 2014, 2016, we feel as though the jail time and the no further contact are appropriate. Nothing further.
Okay, Ms. Bacchus, do you have, on this case, apparently he did get out at some point. Do you have the bond and the stipulations on the bond, or can you get that for me?
Pulling it up right now.
Okay, and you also said that, I didn't hear anything. I've got a 2020 and a 2022. You mentioned something prior to 20 regarding battery or domestic violence.
So
Also,
what I see in 2014 is an ag battery and a probation violation for criminal trespass. In 2015, simple assault, family violence, that one was no pros. 2016, that's escape, 3 FTAs for battery, family violence, criminal trespass, and theft by taking. 2020, 3 counts ag assault. Then we have our case, 2021, and then it looks like I said in August of 2022 of this year, that's where there's the criminal attempt to commit a felony, ag assault, theft by taking, possession of a firearm during a felony. And that's from, I think he was picked up on the same day as this case, which is the 8/2022, but the incident date was 5/2022.
okay, and the 2014 ag battery, was that a conviction?
No, these are all arrests. The only
These are
conviction that I
arrests.
see is 2011 for criminal trespass.
Okay. All right, Mr. Ford.
Thank you, Your Honor. You know, and that's what concerns me sometimes when you read cycles, Your Honor. You know, we're really concerned about convictions, and there's been a criminal trespass, Your Honor. But before I speak, I think it's Jalicia instead of Kalicia, and Miss Wilson, I believe, is on the line, and I'd like to have her speak, Your Honor, before I speak.
Okay, so before Miss Wilson speaks, I need to know from Ms. Bacchus, maybe Mr. Walker can help me. I need to know what the conditions on any bond were. Ms. Lewis, if you can help us, if you have that, I'd appreciate it. Somebody telling me that.
On the one that's on the case right now?
Yes,
that we
on that.
know it was a $3,500 good bond. There was no further contact with the victim, Jaleesa Wilson, and stay away from 183 Mount Zion Road, apartment 4206.
Okay, and who was that? Was that? Say it again.
That was issued by Judge Law on August the 24th.
Okay, thank you. All right, Ms. Wilson, if you would like to address the court, I will need for you to unmute yourself and you'll need to raise your right hand for me. Ms. Wilson, you're not in a good place. And I think that's your left hand. But you.
Yeah, she's frozen.
I'm at work.
Okay.
I'm sorry.
All right. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. What do you want to tell the court?
Mr. Malum and I do share a child. He's not a threat to me. That incident was over 2 years ago. He actually has a job and helps a lot with our current baby that is 5 months old. He also has 5 other kids that needs him as well. Prior to this thing of him getting arrested, he has been working, reporting, and doing a lot better. We haven't had any issues. I do think he might need an anger management class, but other than that, he's really my only help with my child that we have now. And we alternate schedules from work. Like I work first shift, he works second shift. And while he's been incarcerated for the last week or two, it's really been hard. And I really need his support. So the no contact is unnecessary. I feel that it's unnecessary because either way, his family is not supportive. He is the only support with me for our child's sake. So while he's been arrested, I haven't had any type of help or any support. So I feel as if the no contact is unnecessary. We actually are in an active relationship and have been doing a lot better as far as taking care of our kids. And
Okay. So it appears that she has fallen off. But let me tell you, Mr. Ford, Ms. Wilson, are you still there?
She's back, Your Honor.
Did you have anything else to say, Ms. Wilson? You're going to have to get yourself to a steady place. If you're on mute, Ms. Wilson, I don't know if you're talking or not.
I'm actually at work. They wouldn't let me take off for this event. Sorry you couldn't hear me, but I just basically said that I feel like the no contact it isn't right because he's my only support system with my kids. He's a great father. He works and he helps me a lot. And since he's been locked up, I've been having a hard time because I don't have any support from his family or my family as well.
Okay.
And Your Honor, Just briefly, the victim has an open aggravated assault, and there's already a no contact order in her felony case. So
So, I mean, you know where I was going, Mr. Walker. That's why I wanted to
it's a
hear
moot
the
point.
conditions.
Yeah, it's
So,
on her felony case. So it took me a second to find her felony case, but
okay. Well, it's also on his case that he was not to have any further contact with Miss Wilson. And anyone that knows me in this court knows that when you violate someone's some judge's order, and and you obviously do that without caring about it, and that concerns me greatly. So, Mr. Ford.
Well, Your Honor, I don't think there's been any testimony that there's been a violation of the order.
There's definitely been testimony. She says that they've been together. He's on his bond. It clearly says no further contact. Correct, Ms. Lewis? So no further. That is a clear violation.
Well, Your Honor, all I did hear was that they swap out taking care of the children. I mean,
no, from what I heard, that she said that they were together and that he helps her and that they're in a relationship.
Together. My child, I was already pregnant at that incident.
So you have been around Mr. Malam when he's out of jail. Is that right, Ms. Wilson?
I just had the baby. I literally just had a
so
baby.
You have been around Mr. Malam while he's been out of jail.
He's been taking care of his child. I have arrangements where he gets his child for second shift, for first shift.
Ms. Wilson, answer my question. Have you been around Mr. Malam while he's been when he was out of jail?
Yes, we have a child that we just were born.
Okay, so yes, so you have been around him. Is that correct?
Yes.
And you know that that's in violation of a court order, that you were ordered to not be around him, and a court order that he was not to be around you. Correct?
Yes, but we have to communicate.
I understand that, but you might have to, but you can do that. If you've been ordered not to be around one another, that means no contact. Okay, you can deal with your child by a third party, which is what we always do. But by you sitting here and you telling me that you have been violating a court order, that bothers me.
Third party,
Your Honor,
is a child. His
hold on.
His mother is not in his life. Brandon's family is not active. So that our third party has been people like his oldest child communicating with another child because he doesn't have family that will contact my family or contact me.
Your Honor, based on what she's saying, I'm not sure how old the child is, but if this happened in January 14th of 2021 and they just had a child, that means she's become pregnant since then, based on what she's saying. So yes, they've been around each other.
that's what the judge was getting at.
Okay, I'm not going to let you speak anymore, Ms. Wilson, because I think you're getting yourself and Mr. Malam in more difficulty than you anticipate. So I appreciate you being here and giving honest testimony before this court. Go ahead, Mr. Ford.
Thank you, Your Honor. Your Honor, my client was working for and hopefully to keep his job with smart staffing in the warehouse. As has already been put on the record, he has 5 children that he needs to go out and support. Now, I know he has some other issues, but Your Honor, his only criminal involvement that's been on record, his history is only a criminal trespass. And so at this point, Your Honor, the state is asking for 120 days, and Mr. Milan has already spent 15 physical days in jail. We're asking, Your Honor, for that to be reduced to 30 days so he can get out of jail, so he can actually start to help support his family. I'm not clear if I heard anything about the contact, but I know that they were sharing. I heard that they were sharing shifts on taking care of the child. I don't know if that's clear evidence that there's been contact. But at this point, Your Honor, my client does have a stable address. And so at this point, I would ask that there, based on Ms. Wilson's testimony, that there be no further violent contact and that his days be reduced to 30 days, which would give him time served.
Your Honor, just briefly, so basically he wants a no further violent contact order, which would be in opposition to the Superior Court order, which is a no further contact. So that we don't have basis to do that. And also, while there are no convictions of violent offenses, since 2014, there's been, as I pointed out, there's been several violent arrests, and where there's smoke, there's fire. So there's still concern on the state's behalf. Nothing further, Your Honor.
Your Honor, just one rebuttal, and that's my whole concern. When people get arrested and there's no convictions, I don't think they should be even, I would object to those even being mentioned as part of a person's criminal history. Nothing further, Your Honor.
Okay, and but and I agree with you, Mr. Ford. I just get my dander up because they obviously knew that they weren't supposed to be around each other. And they didn't care what the court order was, and they violated it anyway. But I'm going to make specifically clear, Mr. Mullen, because if you do go on probation, and if you do violate by being around Ms. Wilson, whether she wants to be around you or not, she can't be around. She can go back to jail. Do you understand that? The mother of your child could go back to jail because she's around you. And then what is she going to do? So you both need to take that into consideration. So Mr. Ford, I am going to reduce the amount of time. It's going to be 45 to serve 45 days, credit for time served 15 days with the rest of the conditions. Balanced probated, family violence intervention program, no further contact, stay away, and no drugs, alcohol, or weapons. So I do think the time is excessive, especially given the date of this incident. But if he violates it in any way, that it's going to be he's going to be back where he is right now. So if he wants to accept that, then I'm happy to take a plea.
Mr. Milan?
Yes.
You heard what the judge is willing to do, and that is 45 days, and with 15, that would probably give you another week on this charge in jail. And then is that still no further? Yes, that's no further contact. Is that Jalicia or Kalicia? I think we need to get that clarified, Your Honor, because on the Zoom, she's under Jalicia, and the assistant solicitor sounded out Kalicia.
Well, there were two different names in the police report, but based on how she's listed, I would say that it's likely Jalicia.
Okay, all right. So yeah, no further contact, and there also is a stay away, Your Honor. But anyway, Mr. Milan, are you prepared to move forward?
Yes, but I have a question for the judge.
Yes, sir. Well,
I mean,
if
I don't have my mom deceased, and I don't have no one in my family like I got her. Like
Okay, well, stop, Mr. Milan. The judge has made it very clear. There's another case out there that you could cause there could be some real issues. So right now you have a no further contact with Jalicia Wilson. You understand?
Okay.
All right, no further contact.
Okay, and so, Mr. Malabi, you're putting not only yourself at risk of being back in jail, you're putting the mother of your child at risk of being in jail. That has nothing to do with this court, okay? You being around her. So I'm so sorry about the passing of your mother, but you would have, if you have some friends that can intervene, if you have some other type of family members that can intervene, you're gonna need to have someone intervene, because you're not gonna have any contact with Ms. Wilson. I would hate for her to go to jail over this matter because y'all have violated a court order and not stayed and are not staying away from each other. All right, that's not, that's certainly not fair for the child. All right, so does he want to proceed with the plea, Mr. Ford?
Yes, he does, Your Honor.
Okay, thank you. Mr. Malam, it's my understanding that in case 22 CR 005656E, you wish to plead guilty to battery family violence. Is that correct?
Yes.
You have to speak up for me, sir.
I say yes.
Thank you. Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Your Honor, before he pleads guilty, Your Honor, I think he's eligible for a NOLO.
I'm not going to consider a NOLO, Mr. Ford.
He doesn't have any really criminal history on it other than criminal trespass.
I'm not going to consider a NOLO, Mr. Ford.
All right. Thank you.
Has anyone forced or coerced you to plead guilty, Mr. Milam?
No.
I will accept the plea. The sentence is going to be 12 months to serve 45 days, credit for time served, 15 days, balance probated, family violence intervention program, no further contact with Jalecia Wilson, stay away from the incident location, and no drugs, alcohol, or weapons while on probation. I'm going to waive the probation fees for you, Mr. Milam, while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire 12 months. If you violate this court's order, you will be back where you are at the present time. Good luck to you, sir.
You got 24, Mr. Palacios.
And this is going to be an arraignment and a bond hearing, is that correct?
Yes, Your Honor. He needs to get some ancillary matter legal advice. It's not a problem with the state's offer because it's just a first-time DUI offer, and he needs to talk to somebody before I would allow him to go forward with the plea. So I would ask for it to be reset for him to do that. And in the meantime, I would ask the court to consider that a signature bond or a bond lowering would be appropriate. What's his bond right now?
His current bond is a $7,000 split bond, $2,500 surety on the DUI, $2,500 signature on the DUI per se or less safe, $1,500 surety on the driving without a license, and $500 signature on the headlights.
So right now, for the matters before the court, he has a $4,000 portion that is surety, and we would ask the court to consider lowering that to say 1,000 if the court is not comfortable with, or 2,000, 1,500. But if the court is not comfortable with the signature bond, he does have a hold from another county.
All right.
It
Let's start with he needs to be arraigned, right, Mr. McLean? So if that's the case, can we start there?
Yes, Your Honor.
All right, good.
We would waive formal reading.
Okay, let me get there. Mr. Palios, it's my understanding that you wish that, good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Excuse me?
We're doing this by video. Do you agree to have your case heard by video?
Yep.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. You have been charged in case 22 CR 005659D with driving under the influence per se, driving under the influence less safe, driving without a valid license, and no headlights. Each of these charges carries a maximum penalty of 12 months in jail and/or $1,000 fine. My understanding, Ms. McLean, that you waive formal reading of the accusation. Is that correct?
We do waive that. Thank you, Your Honor.
And how do you plead to these charges, sir? Guilty or not guilty? Mr.
Say it again? I don't
How do you
understand.
plead to the charges? Guilty or not guilty?
Like, I don't know, I mean.
Your Honor, may I simply enter a not guilty for him at this time?
Okay. A not guilty plea has been entered on your behalf by your counsel. Mr. Paleos, your case will be returned to the division judge and you'll get notification of your next hearing date. Does he have any previous DUIs on his record?
No, Your Honor.
All right. So you're going to have to take this down, Mr. McLean, as you're doing the bond modification. For the per se, I'll reduce it to $1,000, and for the other two are already signature bonds. For the driver without a valid license, I'll reduce that to a $500 good bond. So it's going to be a total of a $1,500 good bond.
Yes, Your Honor.
Okay.
Thank you.
All right. Good luck to you, sir. What do we have next?
Position number 38, Ringo.
Good morning, Mr. Wingo. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Did you hear me?
Yes.
Okay, you can put your hand down. Mr. Wingo, you've been charged in case 22 CR 005665G with simple battery. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Wingo? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Is there a request for bond modification, Mr. McLean?
Yes, Your Honor. The bond situation on this misdemeanor is darn close to being moot. However, I think it's a $2,500 surety bond. He has a felony case which currently has no bond, and if that changes, that could put this into play. And therefore, I would ask the court to consider making it something like $1,500 or $1,000.
Okay, well, if he gets a bond on the other, then you can come back to this court and I will consider it at that time.
Very good, thank you.
All right,
Yes.
Good luck to you, Mr. Wingo. Who do we have next?
Position number 9 at the sub-annex, Your Honor. I'm sorry, position number 4. Position number 4, Ms. Coleman, Justice Coleman.
Good morning, Ms. Coleman. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're holding by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Ms. Bacchus?
It will be me, Your Honor.
Oh, okay. I'm sorry. Go ahead, Ms. King.
It is 12 months to serve, 24 days, credit for time served, 12 days with the balance probated, 80 hours of community service, and a stay away from all Walmarts in Fulton County. The incident location is the Walmart located at 835 Martin Luther King Drive, Junior Drive in Atlanta.
Mr. Ford?
Thank you, Your Honor. Yeah, I think the only issue we had with the community service see here. Is this number 4? No, it says negotiated. No, Your Honor, we concur with the recommendation of the state, and that's if we move forward.
Okay, Ms. Coleman, it's my understanding that in case 19 CR 001257Y, you wish to plead guilty to theft by shoplifting, is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Coleman. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the 80 hours of community service, then the probation will terminate, okay? All right, good luck to you, Ms. Coleman.
Thank you. Position number 12, Ms. Santana Jackson.
Good morning, Ms. Jackson. I'm Judge Eric.
Good morning.
Good morning, ma'am. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down, Ms. Jackson. You've been charged in case 20 CR 005853F with theft by receiving stolen property and driving while your license was suspended or revoked. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead, Ms. Jackson? Guilty or not guilty?
Guilty. I don't know.
Okay, it's my understanding that you're going to plead not guilty this morning.
That was my understanding as well, Miss Jackson.
Oh, okay, not guilty. I mean, I don't know. I'm just ready to go.
Okay, Ms. Jackson. So I'm going to record your not guilty plea, and your case will be returned to the division judge, and you'll get notification of your next hearing date. What's the current bond?
It's a 2,000 surety,
1,000.
and the state is asking that it remains as set with the same conditions.
Okay, let's see. So she missed a court date, Mr. Ford?
Not to my knowledge, Your Honor. I don't.
Yeah, she has missed multiple, Your Honor. She missed her plea and arraignment with Judge Richardson on 6/24/2021, and then she failed to appear again for an arraignment. I believe it's on a different charge because this one was on May 31st of 2022. No, it probably could be the same one. She
It's
failed
the
to appear
same charge.
again.
She failed to appear on both counters with Judge Richardson.
Okay, Mr.
You're
Ford, what I
correct.
normally do in cases like this is if the division judge has set a bond for failure to appear, I have them go back to that judge to hear the bond modification. Okay, so she'll have to go back to Judge Richardson if she wants the bond modified at this point in time.
Well, Your Honor, that's fine, but we thought we could get the bond modified, Your Honor. She has 4 children. She has and no one to really take care of the children while she's incarcerated. I think there was an issue with the address on the failure to appear, nothing intentional on her part. She had given me some names of individuals to contact to try to get her bonded out, but she has no money to get to be bonded out. Those individuals were not successful as I gave them a call. But Your Honor, at this point, she really does need to get out and take care. She has a 9-year-old, a 13-year-old, and that really need her assistance, Your Honor. So we're hoping that we could get a signature bond at this time.
The state would strongly object to any signature bond in this case due to defendant not coming to court multiple times and also violating probation. She's not following the order of the court in no shape or form. So for that reason, the state would strongly object to any signature bond or bond modification in any way in this case.
Your Honor, and I understand that, but you know, people have circumstances, and then also, as I mentioned, I think there was a concern about her address. It's my client's intention to show up each and every day We've had that conversation, but I think the concern I have is the children who are out there while their mother is incarcerated. So, Your Honor, I believe a signature bond would definitely help this situation.
Okay, and if she's to get a signature bond, she's gonna have to go back to Judge Richardson to get that done. That's what that's my practice in this court. Everyone has an issue with that. If there's no indication that, especially if there's no indication that it was a return to sender regarding these notices, and if there have been multiple times that she's missed court, this court is not willing to modify it at this point in time, but we'll have to go back to Judge Richardson. All right, good luck to you, ma'am.
Next, we have position 27, Ms. Reese.
What was that number again, Your Honor?
It was 27.
27. Okay, thank you.
Good morning, Ms. Reese. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you put your hand down. Thank you, ma'am. Is there a history in this case? It's given that it's a non-negotiated plea.
And Your Honor, before you get the history, the reason it's not negotiating, Your Honor, they have her down as 2 days has served in jail, and I have her for eight days. But Your Honor, it would still be non-negotiated because it's not time served. So I'll talk about that in a minute.
Okay. Ms. Harrison?
Yes, Judge. 4 cycles. Last arrest was August of 2022 for failure to appear. Underlying charge was not indicated. Record indicates in 2022, there was an additional failure to appear. That was underlying charge was driving while license suspended. That was a conviction. Probation just expired on that. She was sentenced August of this year for 10 days confinement and 12 months probation. That's in Gwinnett. So she's on probation for that charge.
What charge is that?
Driving while license suspended.
Okay.
And a 2021 additional driving while license suspended 2021 Douglas County. That was a conviction. Nothing further, Judge.
So just traffic charges?
Yes.
So if I heard PD4 correctly, she's been for 8 days. I think the offer was 20 days.
Yes.
Balance probated. We could do 16 days balance probated.
All right, thank you.
Okay, 16 and 8?
Yes,
Yes,
Your Honor. Balance probated with the conditions listed.
Okay, and the conditions are 8-week anger management. You're gonna null pros count 3. Time served for count 4.
Yes, sir.
Okay, so really there's only 8 weeks of anger management that she's gonna be on probation for, is that right?
Yeah, and that can suspend upon completion.
Okay. That agreeable with you, Mr. Ford?
Apologize, Your Honor, but no. My client has no job at this time, and I think 8 weeks of, I think it was 8 weeks, make sure I'm right, yeah, 8 weeks of anger management, I would think would be excessive. We would like to have her do a 1 or 2 day anger awareness class, Your Honor. I believe she can pull that off, and we would concur with time served, and then also that after she completes that condition, that her probation be terminated. And while she's on probation, we ask that her fees be waived.
I hear the facts, Ms. Bacchus, please.
Yes, Your Honor. This incident occurred on April 22nd of 2018. Officers responded to 622 Terra Circle Southeast in reference to a fight in progress. Upon arrival, the officer met with the caller, Mr. Oscar Altrista Rancal. Altrista is spelled Alatrista, and Roncal is Roncal. He stated that the defendant scratched his vehicle and destroyed some decorative lighting outside of his house. Mr. Altrista Roncal stated that he invited the defendant over because he was having a cookout, and while she was there, he noticed she was drinking an excessive amount to the point where she had gotten intoxicated. So when he asked her to leave, she all of a sudden became irate, started accusing him of stealing money. That's when she walked outside. She scratched the vehicle and kicked his lights. He said that she was very loud, aggressive, cursing and yelling, which disturbed his neighbors. When the officer came in contact with the defendant, he also noticed that she was intoxicated, smelled of alcohol. He said she was belligerent, hostile, making racial slurs about the victim. The defendant admitted to damaging the lighting outside, and while in the patrol car, she continued to make remarks about the officer, hoping that he got hit by a drunk driver and things of that nature. And she was spitting in the back of the car. And so while it has been some time does not necessarily take care of what needs to be taken care of here. The anger management in the state's position is more than appropriate.
Anything further, Mr. Ford?
Nothing other than the fact that, Your Honor, this client does not have the financial means to do 8 weeks of anger management. We're hoping to get that 1 or 2 day anger awareness class.
Well, she'll have 12 months to get a job and complete the 8 weeks anger management. So she should be able to do that within the 12 months. So I am going to order the 8 weeks of anger management if she wants to enter into a guilty plea.
Ms. Reese, are you okay with the 8 weeks of anger management?
Yes.
Okay.
Judge, are you? And we're asking for a waiver of the probation fees.
Yes. Okay.
And termination after completion of the 8 weeks.
Yes. Okay. Ms. Reese, anything further?
Nothing further.
Okay. Ms. Reese, it's my understanding that in case 20 CR 000774E, you wish to plead guilty to criminal trespass, disorderly conduct, and public drunkenness. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept your plea, Ms. Reese. For the criminal trespass, it's going to be 12 months to serve, 16 days, credit for time served, 8 days, balance suspended. For the disorderly conduct, it's going to be 12 months to serve, 16 days, credit for time served, 8 days, balance probated, an 8-week anger management class, no drugs, alcohol, or weapons while on probation. And for the public drunkenness, 12 months to serve, 16 days, credit for time served, 8 days, balance suspended. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And once you complete the 8 weeks of anger management, the probation will terminate, okay?
Okay, thank you.
All right, you're welcome. Good luck to you, Ms. Reese.
Position 31, Ms. Naomi Summers.
Good morning, Ms. Summers. I'm Judge Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me?
Yes, sir. Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Ms. Bacchus?
Yes, Your Honor. This is a negotiated plea. I am pulling up the days right now, but this would be a time served, balance suspended, and stay away from the.
That's 16 days. 16 days, credit for time served 8.
8 days, okay. And the It is the Alta East Apartments located at 777 Memorial Drive Southeast. And that's the stay away location, nothing further.
Mr. Ford?
Thank you. We concur with the recommendation of the state, Your Honor. I ask that we move forward with this plea.
Ms. Summers, it's my understanding that in case 21 CR 005860Y, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Oh, yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Ms. Summers. Good luck to you, ma'am.
All right, thank you.
You're welcome.
We got add on one, Mr. DeBose.
Okay. Good morning, Mr. DeBose. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
I agree.
Yes?
I agree. Yeah.
Okay, thank you, Mr. DeBose. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Swear.
Okay, you can put your hand down. Thank you, sir. Is there a history, Ms. Harrison?
Yes.
All right, hold on, Mr. DeBose.
Cycles, no disposition listed on the arrest, Judge. He has a 2021 theft by taken, no disposition listed.
Okay, so no convictions.
No convictions.
Okay, thank you. Ms. Bacchus?
Yes, Your Honor. In addition to that, he does have just one FTA in February of this year. I'm not sure if the PD may need to go into a breakout or call the jail. The announcement for this case was that he was asking for a time served. Based on what I saw in the history, I'm not opposed to the time served, but we do want a balanced probated anti-theft class. And he can go non-reporting after the theft class.
What is the theft by taking?
1 second, hold on.
And how many days has he served? I'm sorry.
He has served 64, Your Honor.
Okay.
Yeah, and it looks like there were multiple items that were stolen. And it looks like it was taken from his mother. His mother was the victim. And they said that they were able to recover 6 of the bags that were stolen. I guess they were purses that were stolen from the mother. And they were unable to locate the other items. But the mother did.
Go ahead. I'm sorry, Ms. Bacchus. I apologize.
I can't tell you that, Your Honor.
You know what I was about to ask?
Why has he been in that long?
Right.
Yeah, that's the question.
He has not been in that long. He's been in jail for 56 days. And if you want to count the 8 days from the previous arrest on this charge that he FTA on. So if you count those 2 days together, it totals up to 64 days.
Well, that's what I was counting.
Why has he been in jail? Why was he in jail 56 days?
Good question.
Okay. All right. So,
Your Honor,
Mr. Ford, just before you go, I think 60. Say it again, Ms. Lewis.
He FTA. He pretty couldn't make the bond.
Oh, okay. I think 64 days is enough time, Mr. Ford. Is that what
we're
you're
asking for balance suspended, Your Honor. That's all. That's all.
Okay. Yeah, I think 64 days for a first time. This first time theft is enough days. So it's going to be 64 days credit for time served, 64 days balance suspended.
Can we can we have that under first offenders, Your Honor?
If he qualifies for first offender, then I'm happy to allow that. Okay,
Yeah, okay.
all right. Anything further before I take the plea?
Nothing further, Your Honor.
Nothing further from the state.
All right, Mr. DeBose, it's my understanding that in case 21 CR 003507D, you wish to plead guilty to theft by taking, is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
No. No.
You don't want a jury trial, do you?
No.
Okay.
I get what you said. Yes. I get. Yeah.
Yes, you're gonna get out. You're gonna be released as soon as the jail processes you out, Mr. DeBose. So yes, you'll be getting out as soon as possible after we get the paperwork in. Okay.
Okay.
All right. Has anybody forced you to plead guilty?
No.
All right. I'll accept your guilty plea, Mr. DeBose. Sentence is 12 months to serve 64 days. Credit for time served 64 days. Balance suspended. Good luck to you, sir.
If you notation if he qualifies for first offenders, Your Honor.
Yes, of course. And this will be taken with the first offender.
All right. Thank you, Your Honor.
You're welcome. Who do we have next?
Number 30, Mr. Stafford.
Good morning, Mr. Stafford. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Stafford. Ms. Bacchus?
Yes, Your Honor, the state's offer on this is 12 months, 30 days to serve, credit for time served, 15 days, balance suspended, stay away from the incident location, and which is 81 East Park Lane, Northeast in Atlanta, and no further contact with the victim, Julian Moore, and Moore spelled M-O-H-R, Jr., Julian Moore Jr.
Mr. Ford?
Oh, sorry.
No, it's fine.
It's Mr.
Oh, I'm sorry, Mr. Ford. Mr. McClain?
Your Honor, in the jail, I had communicated to him that it was just plain time served, no balance at all, as some cases are. And he wished to take that.
Okay. Mr. Stafford, it's my understanding that you wish to plead guilty in case 22 CR 005654F to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes. Thank you.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you to plead guilty?
No.
I'll accept your plea as negotiated, Mr. Stafford. Good luck to you, sir.
Thank you. Thank you.
You're welcome.
All right.
Thank you.
Who do we have next? Courtroom 2.
Yes, Judge. Position 6, Davis.
Okay. Good morning, Mr. Davis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down, Mr. Davis. This is non-negotiated.
That's correct, Your Honor.
Okay. What's the history?
7 Cycle, last arrest, October of 2021 for criminal trespass and aggravated assault, aggravated stalking in Fulton County. Record indicates, record indicates an open case pending in Fulton County for battery. Case number 20 CR 003156E. Additional open case for battery and cruelty to the children in the third degree, 21 CR 001389E. Record also indicates an open probation in Fulton County for violating Family Violence Protective Order, 22 SC 180544, sentenced July of 2022, 6 months probation. He has one prior arrest only in 2020 that was aggravated stalking. That case was dismissed under case number 20 CP 191642. Nothing further to add.
So he only has one conviction?
Yes, Judge.
Okay, thank you. Ms. King?
Yes, Your Honor, this offense occurred on August 19th. Officers were dispatched to Grady Hospital regarding a dispute. Upon arrival, they met with the security guard who stated that they detained the defendant for assaulting Miss Ashanafi Yerko, ASHENAFI, last name YERKO. The incident occurred in the ambulance bay of the hospital. She was waiting for a ride and asked the defendant if he knew of a nearby street. And the defendant attacked him in the face and continuously hit him. The incident was captured on hospital surveillance video, which the officer was able to observe and record on his body cam. And there was significant bruising to the face that the officer observed. The state is gravely concerned in this case and feels like the offer was more than reasonable under the circumstances, with him having two open violent cases here in Fulton County. One, he's out on a $3,500 surety bond, and the other a $15,000 surety bond, Your Honor. He is not following the laws of this state nor of the court. And for that reason, the time requested and the conditions requested by the state are more than reasonable.
Mr. Ford?
Thank you, Your Honor. And those open cases are not convictions. My client has pled not guilty to those cases, Your Honor. So he only has the one conviction at this time. And we think that the recommendation of state is excessive with 120 days to serve. And he's only spent, I think, 19 days in jail at this time. Your Honor, my client is looking for employment. He has no way to pay the $3,000, I think it's cash bond that is there. However, we believe that this case can be is a time served incident. He has 19 days that he's already served. We believe that due to the fact that he does not have a job, I think that it would be tough to do the 40 hours of community service, and even tougher with the situation of doing 12 weeks of anger management, Your Honor. So at this, and as you can see, he does not have a real violent history at this point. And so I would say that we're requesting that it be time served, that the community service be reduced to somewhere between 10 and 20 hours, and that he do the 1 day or 2 day anger awareness class.
Okay.
And also, Your Honor, that once he's out, that the probation fees be waived, and once any conditions that the judge assigns after he completes those, that his probation be terminated.
All right, what I'm willing to do, Mr. Ford, is 12 months to serve 60 days, credit for time served, 19 days, balance probated, 8-week anger management, 20 hours of community service. The stay away conditions, waive fees, but he's going to be on probation for the entire 12 months.
Mr. Davis, did you understand what the judge is recommending, or not recommending, is saying that you would have to take the plea guilty?
Yes, sir. And I just wanted to state that it wasn't a female I got to find with, it was a male.
Okay, all right. But are you willing, with that clarification, are you willing to take what the judge is stating, that you'll have to do to plead guilty? That would be the 60 days will actually be 11 more days of actual jail time, Mr. Davis. And he's reduced your community service to 20 hours, not 40. Okay, but you will have to do the 8 weeks of anger management. Are you okay with that?
Yes, sir.
All right, we can proceed, Your Honor.
Okay. Mr. Davis, it's my understanding in case 22 CR 005569E, you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
Did you hear what I said, Mr. Davis? Are you satisfied with Mr. Ford's representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea, Mr. Davis. The sentence is going to be 12 months to serve, 60 days credit for time served, 19 days balance probated, an 8-week anger management class, 20 hours of community service. Stay away from the incident location unless you're seeking medical treatment, no further contact with the victim, and no drugs, alcohol, weapons. While on probation, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. But you're going to have to be on probation for the entire 12 months, okay?
All right.
All right, good luck to you, Mr. Davis.
Position 17, Jones.
Good morning, Mr. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Jones. You've been charged in case 22 CR 005603Y with possession of a pistol or revolver by a person under 18 years of age. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead, Mr. Jones? Guilty or not guilty?
Guilty.
No. I'm going to enter a not guilty plea for my client at this time. That's what we discussed.
All right, we'll enter a not guilty plea for you, Mr. Jones. That was entered by your counsel. Your case will be returned to the division judge, and you'll get notification of your next hearing date. It's my understanding that there's a $5,000 good bond in this case.
That's correct, Your Honor. Yes, and the state is requesting that it remain as set. The defendant also has an open felony case, 22 SC 181454 for aggravated assault against a peace officer, criminal damage to property, interference with government property, reckless driving, fleeing, eluding, among other charges. He has no bond on that case, Your Honor. And this case was actually, no, he received the bond in that case and then committed this offense, and he's now being held on that case with no bond, Your Honor. This defendant is not following the laws of the state nor the laws of this court by even committing this offense. And for that reason, the state is requesting that the 5,000 surety and the condition remain as set.
Mr. Ford?
Thank you, Your Honor. Your Honor, my client is 17 years old. He's been a lifetime resident of the state of Georgia, where he has some open cases, Your Honor. My client really does not have any offenses that would warrant a $5,000 good bond, Your Honor. He stays with his mother. I have her telephone number, and Your Honor, we're asking for the bond to be reduced to a $1,500 surety bond at this time.
All right, Mr. Ford, it's my understanding that he has no bond in another case. If he does make bond in that other case, then I'm happy to consider a modification at a later date, but it doesn't seem like this is his big issue at the present time.
All right, thank you, Your Honor.
All right, good luck to you, sir. Who do we have next?
Position 28, Robinson.
Good morning, Mr. Robinson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Robinson, can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Ms. Bacchus?
Yes, Your Honor. The state is going to null process this case. We actually sent a null process over order to Judge Williams, her litigation manager, in the jail on Thursday, so that he wouldn't have to spend the weekend in jail. I believe these are traffic offenses from 2003. He was picked up on a warrant, and so the state is going to dismiss this.
Okay. All right. Good luck to you, Mr. Robinson.
I had another case that I wanted to get rid of that was similar to this. I had talked to my attorney about it. Did you forget, Mr. McLean?
Hi, Mr. Robinson.
Hi.
Yeah, he's got some case numbers he believes might hang him up.
Would Your Honor like me to look that up right quick to see if we could do some global resolutions today?
Well, if I don't want him to be in custody if he's got traffic charges, so if you
Yeah, I'll look right now, Your Honor.
Okay.
Give me the case number.
If you could put it in the chat, that would be great.
He's being held for felony charges. Y'all are aware of that, right?
It's felonies, okay.
Oh, okay. Thank you, Ms. Lewis.
That pretrial, I guess.
Mr. Robinson, given that they're felonies, we can't do anything about those in this court. So you'll have to go to felony court to resolve those matters. Good luck to you, sir.
Okay.
Position 35. Oh, he went to the restroom. Position 23, Murray.
Good afternoon. Good morning, Mr. Murray. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Ms. Bacchus?
Yes, Your Honor. The state's offer in this case is 12 months, 30 days to serve, credit for time served. Looks like it's 8 days, but I'm going to check that because that was the time before the weekend. Balance probated, no further contact with the victim, who is Matthew Ligon, Ligon. Stay away from the incident location of 2453 Coronet Way Northwest. 12 weeks anger management, and no alcohol, drugs, or weapons. And I'm checking those days right now.
He's been in jail for 14 days.
Okay, so we can do 28-14.
Okay, thank you. Mr. McLean?
Your Honor, what case number did you say? I recognize the
Mr. Murray's position 23.
23, right. That is correct. I recognize the Coronet Way. That is what he is asking the court to allow him to do, is the negotiated plea.
Okay, so that means he's going to get out today.
It involves a class.
And 12 weeks of anger management. I'm going to waive the fees, and it'll go non-reporting when he completes the terms, okay?
Correct. Thank you very much.
All right, Mr. Murray, it's my understanding that you wish to plead guilty in case 22 CR 005649F to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Murray, I am gonna waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Thank you.
All right, have a good day, sir.
You too.
Your Honor, could I ask Mr. Murray to hand the deputy a good phone number and ask the deputy to email that to me, because that would help probation have a way of contacting.
Yes, sir.
Did you hear that, Officer Francois?
Yes, sir.
I'm sorry, Judge, I was on the call.
Oh, no, you're
Yeah.
fine. They just want his phone number put in the chat.
Right.
Mr. McLean.
You could, yeah, chat's fine. Put it in chat's fine. Thank you.
To put whose number on the chat?
Mr. Murray's phone number. If he's got a good phone number, we need it.
What is it?
I don't mean to hang us up here. Mr. Murray, you got a good phone number?
7.
Just give it to her. That's fine.
What?
2747.
2777?
2747.
It's in the chat, Judge.
Thank you.
Got it.
All right, who do we have next?
Position 25, Ponder.
Good morning, Mr. Ponder. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. Ms. Bacchus.
Yes, Your Honor. The state's offer is 12 months, 20 days to serve, credit for time served, 10 days, balance suspended, and stay away from the incident location of 890 Cleveland Avenue in East Point.
Mr. McLean.
Your Honor, what case number was that?
Position 25, Mr. Ponder.
Okay, Mr. Ponder, right. He agrees to the negotiated plea and asks the court to accept it.
Mr. Ponder, it's my understanding that we wish to plead guilty in case 22 CR 005667B to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Ponder. Good luck to you.
Your Honor, just
Yes.
to clarify for the record, it is going to be 30-15.
Okay, so still a time served plea?
Yes.
30 days with 15. 30 days to serve, credit for time served 15. All right. Good luck to you, sir.
Thank you, sir.
Position 2, Chester.
Good afternoon, Mr. Chester. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Thank you. You can put your hand down. Thank you, Mr. Chester. You've been charged in case 22 CR 005612F with simple battery family violence. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead, Mr. Chester? Guilty or not guilty?
Guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. What is the present bond?
$2,000.
I'm sorry, say it again.
2,000 surety.
Okay, thank you. Is there a history, Ms. Harrison?
I'm showing 8 cycles out of Florida. He has a, let's see. Last arrest was June of 2020 for battery, touch or strike. That was a dismissed case. Prior to that, he has a 2019. I'm not showing any convictions, Judge.
Okay, thank you. Ms. King?
Yes, this case occurred on August 21st of this year. Officers were dispatched to a domestic dispute at 2200 Pryor Road Southwest in Atlanta. Upon arrival, they spoke with the defendant as well as his ex-wife, who was the victim in this case, Mary Ann Chester. Those are all traditional spellings. They had lived together for over 10 years prior to their divorce. The defendant advised the officers that he took the victim's phone and went in his room, and his stepdaughter, who also lives in the home, Renisha Northern, went in and took the phone from him. At that point, the defendant snatched the phone from Ms. Northern and pushed the victim near the front door. After he pushed her, he also struck her in the face. And no, the victim struck the defendant in the face, and then the stepdaughter jumped in defense of her mother. After the officer spoke with all the parties, he determined that the defendant was the primary aggressor, which is why he was arrested in this incident. While the defendant does not have a substantial history in Georgia, he does have a substantial one out of state, which makes the state feel that he is a flight risk. Also, with them being divorced and he still having access to her, the state is concerned about intimidation of the witnesses of both her and the stepdaughter that resides in the home. For that reason, the state is requesting that the 2,000 surety remain as set, as well as the conditions.
Ms. Ford?
Thank you, Your Honor. Your Honor, the alleged victim and my client, the defendant, they share children together, and he's helping with the support of those children as well. He's a manager of Grease Monkey, and
hi, buddy.
I didn't hear who that was.
Whoever, Mr. Cooper, Daryl Cooper, you need to mute yourself, please. Thank you. Go ahead, Mr. Ford.
I apologize, but yeah, he's working on this. He has a valid CDL license. His concern is that he's been a manager for the last 9 months, and any further incarceration could jeopardize his financial position and jeopardize the financial position of his family. We're also asking for no further violent contact because he does share in the support of the children. Even though that they're divorced, Your Honor, they have been living amicably together. So at this point, Your Honor, we're asking for, he's been in custody for 16 days. We feel a signature bond at this time due to the fact that he has no real criminal history here in Georgia. And one fact, he did call the police. So it's not like he's a violent person trying to get away with anything. He called the police. He was just determined because, as you can see, he was struck during this particular situation. He was just determined to be the aggressor for whatever reason. So at this point, Your Honor, this is a person who's trying to provide, has a good job, has a CDL that he wants to make sure that that stays intact as well, Your Honor. So we feel that no further violent contact with the alleged victim or complaining witness, and a signature bond due to the fact that he's already spent 16 days in jail and really does not want to lose his job.
All right, so I'm not going to let him have any contact, Mr. Ford. Does he need to go back to that address for any reason? He stays someplace else besides the Pryor Street address, right?
Yeah, well, that was something he was very adamant about to me, was that he needed no further violent contact because that's the only place he has to live.
Okay, well, I'm at this point in time, I'm not willing. I'll let him out, but but I'm not gonna allow him to get out and go back to that residence or have any further contact with Ms. Chester at the present time. Has anyone Was that in the original order, Ms. King?
Yes, it was, Your Honor.
No further contact?
Let me verify. I
Um,
believe it's what I saw, but I will check again.
Yes, it was no further contact with Mary Ann Chester, and stay away from 220 Power Road Street, and may return back one time with law enforcement to make sure the victim is not there. If the victim had left to stay, he can remain. If not, then he can retrieve his personal belongings and have to leave, but he had to return back with a law enforcement officer to see if she still lived there.
Okay, so Mr. Ford, I'm gonna keep, thank you, Mrs. Lewis. Mr. Ford, I'm gonna keep all the same conditions in place, but I'm gonna give him a $5,000 signature bond through the jail. Your client has his hand up.
what do you mean? That's my residence, sir.
Okay, well, it was determined
Everything-
prior.
everything in the house-
It was determined prior that by another judge that you could go back there on one occasion with law enforcement if Ms. Chester is not at that residence, and you can stay there. Given that you can have no further contact with her, if she is there, then you're gonna have to find someplace else to go until this matter is sorted out.
I have no other place to go, Your Honor. That is my residence, sir. That is
Okay,
my
well,
residence. I have no other place to go. I know no one in Georgia, period. No one. I know
Which
no one.
further shows he has no ties to Georgia, Your Honor. So the state's renewing it. It's an objection to a signature bond is.
Can you get on the Zoom?
Again.
Home now. I wish he'd come on. I miss him so much.
okay, well, that's gonna be my my ruling. So we can either not modify it and let it stay as it is, or I can modify it and give him a signature bond, but the conditions remain in place. So which do you want, Mr. Ford?
Well, you know, I want the signature bond, Your Honor, but I just finally got a hold of Miss Chester, and she's very adamant about him coming home. And so,
Your Honor, you're familiar with the cycles of violence.
I am not a
I
violent
think it would be very inappropriate under the circumstances.
Hold on.
To allow.
Ms. King, you don't have to argue. I've already made my ruling. So.
Thank you, Your Honor.
Okay.
All
So
right.
you all can keep arguing if you want to, but.
All right,
but
all right, Your Honor. Mr. Chester, you've heard the judge at this point. He said that he will give you a signature bond, which will allow you to be released, but you cannot go back to the incident location, which is your home, only one time with police officer to receive whatever, retrieve what you need. And at that point, you need to stay no further contact with Miss Mary Ann Chester. Are you willing to take that at this time?
I'm willing to take that, but I don't want to move out of the state because the state is crazy.
That's okay. That's okay. That's okay. Yes, Your Honor, we're willing to move forward.
Okay, so if you'll make that modification, Mr. Ford, then
Was that a $5,000 signature bond, Your Honor?
Yes, through the jail.
Okay, jail. Okay.
All
right.
What does that mean?
Good luck to you, sir.
Hold on. Mr. That just means you get released, okay? And I'll talk further.
Okay.
Position 21, McDuffie. No, you're fine.
Let's see. Good afternoon, Mr. McDuffie. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Ford, what are we doing with Mr. McDuffie today?
Your Honor, he is prepared to plead guilty to the recommendation of the state, which I have is 12 months to serve. 12 months to serve 4 days in jail, credit for 2 days, and balance suspended, and to stay away from the incident location, 530 Pace Ferry Road. That's what we're willing to do today, Your Honor. We're gonna plead. I think that's a negotiated plea.
Is that the negotiation, Ms. Bacchus?
Yes, Your Honor.
Okay. Mr. McDuffie, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can put your hand down. Thank you, sir. You have been charged in case 22 CR 002065J with criminal trespass. This charge carries out with criminal trespass. It's my understanding that you wish to plead guilty to this charge. Is that correct?
Oh, yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Oh, no, sir.
This afternoon, you've been represented by counsel. Are you satisfied with your counsel's representation?
Oh, yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Oh, yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. McDuffie. Good luck to you, sir.
And Your Honor,
Your
can I
Honor,
just,
just to make sure the days are correct, it's 18 and 9.
Okay, 12 months to serve, 18 days, credit for time served, 9 days, balance suspended, and a stay away.
and Your Honor, and thank you. I don't know where I got, but Your Honor, I just want to ask Mr. McDuffie one thing that I had to speak with him on the phone today. Are you giving me permission to sign for you, Mr. McDuffie?
Oh, yes, sir.
Okay, thank you, Your Honor.
Yeah, I'm sorry if I missed it, but did we get the stay away address?
Yes, it's 530. I have it on the report
Okay.
already.
It's
Okay.
the Ashley Gables Apartments at 530 East Paces Ferry Road.
Yeah, I have
Okay.
that already down.
Okay. Good luck to you, sir. Who do we have next?
Position 35, trial.
Your Honor, I have a special request.
Okay,
The special request would be for the court and the prosecutor assigned to Trout and the prosecutor assigned to 34, Mr. Terry. If we could have a breakout room, I would waive the presence of the defendants. I need to inquire as to the proper direction.
What position is Mr. Terry?
Terry
34.
is 34, Trout is 35.
Okay,
that the same
so we
prosecutor or
are
different?
hearing that case when I thought he was being reset to the competency calendar.
Well, I'd like to bring something up to the court on 34 and 35 together, but just as a breakout session, like approaching the bench.
Okay.
all right.
But those numbers are 33 and 34 by any chance?
No, 34, 35.
Okay.
All right, so if you're placing,
33 is already going to the competency.
So
Okay.
you're referring to 34 and 35 now.
Right. 34 and 35 is what I'd like a breakout session on with the court and the prosecutor. Maybe the same prosecutor, maybe two prosecutors.
It's the same prosecutor. That would be me and Mr. Walker.
Okay.
Okay. Give me a second. Everybody should be able to go back into the same room that you were in. All I have to do is ask Mr. McLean in. So just
Okay.
invite yourself back to the room. All you do is have to push down your more button and you will see to go back into that room.
Okay, there we go.
I don't see it on mine, Miss Lewis.
Not
It's
there yet.
I don't see it either.
Underneath more, you have to hover over it and it's going to have where the 3 dots are at. If not, I'll just close y'all all out.
Yeah, once I click on more, it says chat, show chat previews, record on this computer and live transcript.
All right, y'all don't see it and it's there, but that's okay. I'll just close everybody out, put y'all in a new room.
Sorry.
It's okay. Give me a second. Mr. Ford, can I ask you a question? On position number 1, you indicate there was a private attorney. I'm not seeing an entry of a private attorney on that case. How did you get that information?
From Mr. Alford himself. He said he has a private attorney, he has some other cases, and he said his case is Brian Steele. His
Well,
name.
he hasn't found an entry on this case, and he was never contact for this counter.
Okay, well, you're probably just gonna have to reset him because he was pretty adamant that he has an attorney already.
Okay, well, Mr. Stills needs to let his attorney know to file an entry where he can be associated with the case for the next counter, because we have no entry of him representing him on these cases.
All right, so is this Mr. Trout? Courtroom 2?
Yes, it is, Judge.
All right, good afternoon, Mr. Trout. I'm Judge Eric Marr. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
All right, you have been charged in case 22 CR 005655G with loitering and prowling, willful obstruction of a law enforcement officer, and giving a false information to law enforcement. It's my understanding that the state is offering you a time-served plea on this. Was that something that you were willing to accept or not?
No.
Okay. As such, what is the current bond in this matter?
$1,000 surety, Your Honor, $250 on the first 2 counts and $500 on the 3rd count.
Are there any conditions?
Give me one moment.
At Market Boulevard.
Say it again, Ms. Lewis, I'm sorry.
Stay away from Burger King at 1425 Market Boulevard.
Okay, so I'm gonna convert these.
Your Honor, before
go
you
ahead,
give
Mr.
your
Walker.
ruling, can we at least hear from pretrial, get a factual basis? I understand you want to give a signature behind, but the state is objecting to it, especially based on the information that his attorney has provided, which he essentially said he's going right back to Burger King.
No, I didn't say that.
I thought he said that basically.
Okay, let me
We're not gonna go into
record.
that, but
Let me
can we
just put on the record that we had a conversation regarding Mr. Trout when we were in a breakout room. If you want to put that on the record with additional information from Ms. Harrison from pretrial, I'm happy to do that. So Ms. Harrison, what's the history?
7 cycles. Last arrest was June of 2021 for carrying a weapon without a valid license in Doraville, Georgia. No disposition on that arrest. One moment. He has. Okay, so he has history in Washington, California, Georgia, and Virginia. His arrests in the state of Georgia are, one moment, it's 2 cycles. Last arrest and the first one in Georgia was 2019, obstruction of law enforcement officer in Roswell, Georgia. No disposition listed on either of those arrests.
Your Honor, the factual basis for this case, this incident occurred, I believe, on August 22nd of this year. Officers responded to that incident location of 1425 Market Boulevard, an abandoned Burger King, in reference to a third-party caller stating that they saw 2 people climb in the window of a vacant building. And upon arrival, the officers began to search the outside of the building. They saw random bags and a cooler and some other items on like what would be, I guess, the porch or the front area of the building. When going around to the back, they saw that the door was slightly ajar, so they pulled it open. They went in. They pulled their firearm, of course, to sweep the area and made their presence known, asked someone to identify themselves. They then went into the freezer. The defendant was hiding in the freezer, and they found a lot of items that indicated that basically the defendant was squatting. When the defendant was asked his name, he gave a name of Joel Troop with the date of birth, August 10th, 1990. And when they asked to confirm the spelling, well, he gave that spelling for that name, but they found his driver's license on him, with which they were able to confirm that it was not the correct spelling and date of birth. They then tried to conduct a search incident to arrest. He would not comply after multiple commands, and so they had to use restraint to gain control of the defendant. Again, Your Honor, the state's offer was 12 months to serve, 30 days credit for time served, 15 days balance suspended, stay away from the incident location. And in the alternative, if the offer was not taken, we would ask that $1,000 surety bond stay in place. Nothing further.
Mr. McLean?
Your Honor, just a quick mention of the facts. He did, before he stated what the state said just now about his name, he did say Joe Trout, so he gave the correct date of birth. So he is Joe Trout. That's how it's pronounced. But the only difference would be the D, and I doubt that particular charge would be a good charge, because that was his initial thing. And if they asked him to spell it second, and if they didn't hear the D, that's a minor point.
Well, he gave an L and a P. He said Joel Troop, not Joe Trout. That's different.
The police report says his first response was Joe Trout.
I'm aware of that.
It's okay.
Right.
It's okay.
But he is Joe Trout. So, and he gave the correct date of birth. So it's hard for them to miss it in the computer, D or no D. The point is that he would like to ask for a signature bond because of the level of the charges, and he has stated that he will stay away from that abandoned Burger King. It is not in use. The freezers were referred to as old freezers, so he was not chilling.
All right, Mr. McLean, I am going to convert the good bond to a signature bond with the same conditions as the good bond. So if you can get that to Ms. Lewis, we'll get that entered. Good luck to you, Mr. Trout.
All right, you done. The ring.
That's for position number 10. It's going to be a medical reset.
I'm sorry, Judge. The last guy, was it going to be a ring, or he just is a bond modification?
It was just a bond modification.
Oh, okay.
Did it need to be arranged? All right. I'm sorry. Can we?
We could do that.
File a waiver. It's up to him. Whatever y'all want to do.
Yeah, we'll waive formal reading of the accusations.
Can you file a written waiver, Mr. McLean?
Yes.
Okay. All right.
And
Thank you.
Can you tell me one more time, Your Honor, that you converted it to a signature bond? It's still the same amount, and is it through pretrial or the jail?
It's through the jail, same amounts.
Thank you.
Okay, and so we were saying that 10 is a medical reset, is that right?
That is correct, Judge.
Okay, and that's going to be, this is your case, Mr. Ford. You with us, Mr. Ford?
Okay, to the 13.
Apologize. I was. We don't have. Why is it a medical reset set through the jail?
That is correct.
Yes.
Okay. Because
Was
I
this
did.
Because I wanted to reset for Thursday. I mean, I don't know what the well, there's jail time that's an issue. So
The 13 is on.
next Tuesday, Mr. Ford.
That's fine, Your Honor.
Okay, we'll reset Mr. Holland for next Tuesday. Is there anybody else that we've not seen? Okay, thank you so much.
Wait, Devon.
Oh, yeah. What was that?
All right, so what are we doing with position one, Mr. Alford?
Your Honor, when I went to visit Mr. Alford, he said he had a private attorney, Mr. Brian Steele, who was handling this case and other cases that he has. So I'd ask that you reset that to maybe the next, to SAP Tuesday.
Okay, that's reset until next Tuesday also. All right. And does that look like that took care of everybody on the 9 o'clock calendar?
Let me see, I still have some files here, Your Honor, so I want to make sure.
Okay. I want to make sure before we let courtroom 2 go, if anybody has an objection.
Set medical. Yes, that's everything. That's everybody, Your Honor, for me.
Okay, thank you all. I guess I'll see you in a little while this afternoon.
Judge,
All right, Judge,
it's
thanks.
Ms. Thomas from
It's
JCS probation. I'm having the issues getting these contact information from public defenders. So if I could, if y'all could read the chat with the D Thomas 2 at judicialservice.com. We can't call nobody if we don't have anything, and it's gonna make them fail if we don't have anything.
Well, don't, because we always send in the contact information sheet. Is that not happening?
That person know who I'm speaking of. He's on the line. He knows. So, but it's fine. I just wanted to let it be known that I've been asking and asking.
Okay.
Okay, so Ms. Thomas, tell me exactly what it is that you're gonna need. You're gonna need their contact information sent to you by the public defenders?
Yes, because we
Okay.
can't, once they talk to them, we don't know them. We don't have no information. We can't call them, set an appointment. We can't do anything.
Well, I will let people know, Your Honor, because we normally send the contact information sheet, at least I do, each time I send in something. So I don't know where that's happening.
You already said it wasn't you, Charles.
We try every time, and usually.
Yeah, well,
usually
I'm not trying to say it's me, but I want to make sure that we're getting the information to individuals. So if that's something I need to pursue, I will do that. But
I've got some blank contact sheets, and we'll try to fill them out as best we can for each person we've got.
All right.
So
well,
you are not asking, and y'all just kidding. I'm sorry.
No, I'm just saying I think what Ms. Thomas is saying that you all aren't doing your clients any service if she's not getting the information and that they're failing because she doesn't have information regarding how to get in touch with them. Is that basically what you're saying, Ms. Thomas?
Yes. Yes.
Okay. So she's trying to assist the court and she's trying to assist your clients to make sure that they don't fall through the cracks and have to be back here because of not reporting to probation. So let's see what we can do. If you all can speak to whoever needed to speak to, Mr. McLean and Mr. Ford, to let them know that that's a problem.
okay.
I think they're saying it's a problem with me, not Mr. Ford.
Well, if it's a problem, it's a problem. So
it's a problem. Yeah, I'm not singling myself out, but we want to make sure you get your information. We'll definitely stress that you get the contact information sheets each and every time. Okay.
Okay. If your defendant do not have a contact information or address, could y'all just make them appointment and just send me the appointment so I can put it in the system so that they know that they have an appointment? If y'all
that's what we have to do. That would be great because a lot of them don't have anything.
Right. So you can send that to me once they on their contact sheet or whatever, their name on it. I can make them appointment. As long as y'all making them aware that they have an appointment at 132 Mitchell Street when you set that appointment.
Right.
I can take that because I'm having a problem, Mr. McLean.
When they're so homeless and they don't even have a phone number, I tell them just to show up at your door in about a week. I always give them the address.
Okay, well, that's not
Mr. Palmer, we do see you with your hands up.
Ms. Thomas doesn't seem to be too happy with that either.
Thank you.
Just hold on tight. All right. I know you're here. Give me a second.
All right, just making sure. All right.
You just need to change your name on your Zoom user to your name.
Okay, thank you, Ms. Thomas. We appreciate you updating the court. Let's see if we still have one case that we need to handle. So, all right. So thank you, Ms. Thomas. We'll see what we can do about that. We have a TV bench warrant case, the 11 o'clock calendar. Who's representing Mr. Palmer?
I will be, Your Honor, but I have not had a chance to talk to Mr. Palmer as anyways, to put him in the breakout room with me.
Okay, Mr. Ford, would you mind if we went over the calendar while you're speaking with Mr. Palmer?
I do mind with that because I'm going to have to report everything that happened today. So if you want to go over that first.
No, well.
I can go over the calendar right quick, Judge. I'm ready.
Okay,
I will need someone to say if it was a guilty plea or a nolo. That's the only thing I need.
I'll be specific.
All right, thank you, Ms. Lewis. So we'll go over the calendar and then we'll go back to the 11 o'clock calendar. Okay.
Okay, everybody's ready. Position number 1 is going to be reset for the SAP September the 13th. Position number 2, defendant was arraigned not guilty. The case is reset for a jail jury. Further notice, the bond was modified to a $5,000 SOB through the jail with the same conditions. Position number 3 is going to be reset to the SAP for September the 13th. Position number 4 was a guilty plea. Position number 5 was a null pros. Position number 6 was a non-negotiated guilty plea. The case is reset for, non-negotiated guilty plea. Sorry about that. Position number 7 was a non-negotiated plea, guilty. Position number 8 was a negotiated plea, guilty. Position number 9, defendant waive arraignment. The case is reset for jail jury for the notice. Position number 10 is a medical reset to SAP for September 13. Position number 11 is going to be reset to the SAP for September the 13th. Position number 12, defendant was arraigned, not guilty. The case is reset for jail jury for the notice. Position number 13 was a non-negotiated plea, guilty. Position number 14, defendant was arraigned. Case is reset for jail jury for the notice. Bond modification was denied. Position number 15 was a NOLO, non-negotiated plea. Position number 16 was a global resolution plea for both cases. The other case numbers 22 CR 005722 Y as in Yolanda. That was a guilty plea. Position number 17, defendant was arraigned, not guilty. Case is reset for jail jury for the notice. Position number 18, the defendant was released on bond. The case is reset for the notice. Back to the original division judge. Position 19 and 20 was a no-low plea, not negotiated. Position number 21 was a plea, guilty. Position number 22 was a non-negotiated plea, guilty. Position 23 was a negotiated plea. Position number 24, defendant was arraigned. The case is reset for jail jury for the notice. A bond modification of the good bonds. Per se, alcohol is going to be $1,000 good bond and drive $1 license. Valid license is going to be a $500 good bond. Total of $1,500 good bond. Position number 25 was a negotiated plea, guilty. Position 26 was a negotiated plea, guilty. Position 27 was a non-negotiated plea, guilty. Position 28 was a null pros previously. Position 29, defendant was arraigned. I don't think he took a plea. Yeah, defendant was arraigned, not guilty. His case will be set back to the SAP counter for a revolution, I guess, about the bond, September 13th. Position number 30 was a guilty plea. Position number 31 was a negotiated guilty plea. Position number 32 was negotiated guilty plea. Position number 33 is reset for the competency counter for 9/15. Same announcement for 34. Position 35, expecting a waiver or arraignment. The case is reset for jail jury. further notice. Well, it'll be trial further notice because the defendant is receiving a signature bond with the same conditions. Position number 36 was a negotiated plea guilty. Position number 37, defendant was released in case we set further notice. Position 38 was arraigned, not guilty, cases reset for jail, jury, further notice, bond was denied. The add-on counter was a non-negotiated plea. And the first offender was received on that case. That
All right,
completes.
questions, concerns?
Just one. Let me go to it right now. It was number 23, I think it was. Yes, 23. Was that guilty?
Yes, that was a guilty
Yes.
plea.
All right, then. Thank you.
And I guess the DB counter, I guess I can put y'all in the breakout room right quick.
Yes.
Okay.
All right, so we'll be in recess until Mr. Ford comes back.
For those who getting plea paperwork, please make sure it's sent to me in the null process. I don't think I got all the null process. I think I got 2 of them. Mr. McLean, can I ask you a question right quick?
Sure.
Are you gonna come down to my office to submit your paperwork, or you're emailing it to me?
I've got enough forms, but I do need to know, I need to make sure that I understand which ones were waiver of arraignment. That was, do you have the list handy, or I can figure it out?
I can tell you, it wasn't that many. Give me 1 second. I think you need to do one for
Are you in J150?
Yeah, just make sure you just ask for me when you come to the front counter. I'm really
Yeah,
in J 135, but just make sure you just ask for me to, or tell them to give the paperwork to Miss Lewis, Katrina Lewis.
Yeah, I'm just,
in the office.
as you can see from the wooden walls, I'm just upstairs.
I know, that's why I was asking.
Yeah, you know where I am.
Yeah, your position number 35, Joseph Trout. I did a waiver arraignment on him and the bond modification. Paperwork on him. So I need 2 sets of piece of paper from you on him. And I think that was.
Yeah, I did waive arraignment on a couple more people though, and I marked it down, so.
I think that's the only one I had. I think everybody else was arraigned in person.
Well, there were a couple more people, but I've marked it down on my calendar. I have 2 or 3 versions of the calendars staring me in the face.
Well, I want to make
But
sure
I've
we're
marked
on the
it.
same page here. I don't need no extra paperwork if I don't need it.
Yeah, I'm gonna get you a bond reduction in Palacios number 24. I'm working on that. And the rest of it's plea paperwork. But my arraignments waived were Timothy Rutledge 29. I'm gonna waive arraignment in that.
Okay, I thought he was arraigned and then his case is reset for the SAP regarding his bond condition. But
Yeah.
that's fine. You can submit. You can submit if you want to. I had him as arraigned already.
Okay. And the other one was Wingo 38.
38. He was personally arraigned.
He was here. He was here.
Yeah,
I
he
just
was
said I would
personally-
waive the formal reading, right? But I can do it in writing too.
No, I don't need that in writing. He was already arraigned in front of the judge.
Oh, he was already arraigned sometime before. I got you.
No, he was
Okay.
arraigned in front of the judge.
I see what you're saying. So what about number 29? Should I do it or not do it?
No, do not. 29. No, I do not. Only one I need from you is 35. That's the only paperwork.
35 Trout. I'll do him then.
And I need
Okay,
the,
I will pull up. I've got on the computer here. I've got a waiver of arraignment somewhere. I can get that pretty quick.
Okay.
Okay,
No problem. Thank you.
thanks.
We're all set, Your Honor.
Okay, let's see, who's presenting for the state?
That would be me, Your Honor.
Okay, go ahead, Ms. Bacchus.
Your Honor, based on, the state would object to setting aside the bench warrant. We do have, he has a limited history. He has 3 cycles, but he does have an FTA on his record from 2017. And based on the nature of the offense and the not responding, or the history of not responding to legal process, the state would ask that you not set aside the bench warrant.
What did he miss, Ms. Bacchus?
I'm sorry?
What court date did he miss?
1 second, pulling up I believe he missed, it looks like it is for,
It
looks
was for
like
the
it is
August
for-
22nd P&A for Judge Besson. August 22nd P&A.
And his notice was returned due to insufficient address.
It was supposed to go to my address, but I got nothing because that was the arresting address, 220 Spalding Trail.
Okay, let's see. And he's only missed this one court date, is that correct?
On this case, that's correct.
On this case.
Okay, Mr. Ford, do you have a correct address for Mr.
Yeah,
Palmer?
I have 1124 Brookview Ave, Atlanta, Georgia, 30340. I have his telephone number, email address, and his mother's telephone number. I could put those on a contact information sheet. If we set aside the bench warrant, when I put that information in, Your Honor, I'll have the contact information sent as well.
Okay, Mr. Palmer, this court routinely gives you 1 chance to miss a court date and set aside a bench warrant. You won't be given another opportunity. If you move, it is up to you to make sure that the court knows where you are. You should continue to keep in touch with the court for any court dates that are coming up. So given that you have only missed 1 court date and that you're before us today, I'm going to let that be your 1 chance to miss a court date. So Mr. Ford, make sure that we have his correct information. So I'll set aside this bench warrant this 1 time. All right, Mr. Palmer?
All right, thank you.
If you come back before us, it won't happen again though, okay?
All right, what?
All right, good luck to you.
right, thank you.
Mr. Ford, I would need 2 things from you.
What's that?
I would need 2 things from you. I would need an order to set aside the bond forfeiture.
Yes.
And I would need all his contact information, email, with everything that you need to give me, because it's not updated in the system at this time.
Yes, I will be sending that in with the contact information form, okay? I'm filling it out now.
Okay.
Yep, I have
All right. Okay, so if there's nothing more, that concludes today's business. Thank you all.
All right, thank you, Your Honor. Good seeing
Thank
you.
you, Your Honor.
Okay.
Your Honor.
I've got to be back in court in an hour, so let me run get something to eat.
Awesome. Thank you.
All right.